Senate Judiciary Committee will come back to order. First bill up is going to be Senate File 1524, Senator Dibble on unmanned aerial vehicles.
Thank you, Mr. Chair. If we could start with Senate, I'm sorry, did you already say Senate File 1524?
1524, just going to see we have an amendment here. This is your first stop, so it's an author's amendment.
Yes, Mr. Chair, it's the A3 amendment.
All right, Senator Oumou Verbeten moves adoption of the author's amendment, the A3. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment's adopted. Senator Dibble, tell us about your bill, please.
Thank you, Mr. Chair and members, for the opportunity to present Senate File 1524. I'd like to also thank my co-author, Senator Limmer. It's brought by the Minnesota Sheriff's Association, and it has to do with drones, or what we call unmanned aerial vehicles, UAVs, and the circumstances in which they are permitted to be used. The proposed changes, Mr. Chair, the purpose is to enhance public safety, emergency response, and investigative efficiency, while also, I think, which has been important to myself and Senator Limmer in this committee and this legislature, to ensure accountability and transparency in the use of UAVs by law enforcement. So just very quickly and very simply, it envisions three circumstances in which UAVs would be permitted, with a slight expansion, to preserve, and it's a slight change in this language, which you see on the A3, to preserve or protect evidence from the imminent risk of destruction. We can have the sheriff here describe what those kinds of circumstances are when it's time for him to testify. It has come up that flying UAVs over private property sometimes needs to occur, but that should occur with the written consent of the owner or the occupant of that property. And then, of course, for whatever reason, I think this is somewhat of an oversight, but for search and rescue options, of course, you can imagine that drones would be very, very useful in those circumstances. So this proposal calls attention to that and makes sure that that's a clear and allowed use of UAVs. So with that, Mr. Chair, I can pause for questions, or we can go to our testifiers.
We can go to our testifiers. Sheriff Habel, welcome to the committee.
Good afternoon. Thank you, Chair Latz, members of the committee. It's my honor to be before you today. I'm Scott Habel. I'm the sheriff in Renville County, about 70 miles straight west of where we're sitting. I'm here to testify today in support of Senate File 1524. As mentioned, the Minnesota Sheriff's Association sought this bill. It aims to modernize existing law regarding UAV use by law enforcement. Passage of this bill will align policy with public safety needs by doing three things. One, strengthening crime scene preservation. Two, ensuring that law enforcement can quickly and effectively respond to missing persons emergencies. And three, allowing us to adequately train our officers and deputies for those emergencies. So first, the proposed updates authorize UAV use to preserve and protect evidence from imminent destruction, allowing law enforcement to act swiftly in preserving critical information that could be lost or tampered with before search warrants can be issued. In that instance, think about outdoor crime scenes and the ability to document those, not to change the evidence, only to document the evidence, perhaps in light of incoming weather or other things that Mother Nature might throw at us. Secondly, as you know, UAVs are an incredibly effective way to search in time-sensitive missing persons cases. The language in this bill would grant law enforcement explicit permission to use this critical tool to locate missing individuals more quickly and then improve emergency response outcomes. With regard to training, as you can imagine, a deputy piloting a UAV is only as good as his or her training. And under current law, officers and deputies can only conduct training flights over public areas. In my county, we have massive cornfields. Sometimes we're called to search for lost or missing children or the elderly in standing corn. A UAV with a well-trained pilot would be an invaluable asset in that situation. Unfortunately, though, there are no cornfields in public areas, so we quite literally have no way to train for that scenario. So when a deputy responds to a small child lost in a field, If he or she were to use a UAV, it would be literally their first flight searching an agricultural field. They'd have to learn as they go rather than being trained, ready, and experienced in that situation. So in this business, we do our best to train for any situation. Unfortunately, the current law doesn't allow us to train for this one. Similarly, from time to time, I'll get a call from a farmer that says, "Sheriff, my cattle are out in my cornfield. It's 80 acres attached to the pasture. I don't know exactly where they're at. I want to round them up. Can you come out with your drone and help me?" Today, the answer is no, I can't. The law doesn't allow us to do that. So with the language in this bill, hypothetically, we get this farmer's written permission to fly his field. We go find his cattle for him. Not only do we find the cattle, we have a positive contact between law enforcement and the community that we serve. This same farmer and others just like him will most likely offer again written consent and allow us to set up training scenarios and fly their fields and practice these things. Now, when that small child is missing in 9-foot-tall corn, we deploy well-trained, experienced deputies to search in that environment. This just makes sense. The Minnesota Sheriff's Association fully supports these updates as they enhance public safety, they improve operational effectiveness and investigative integrity while ensuring UAV use remains clear, lawful, transparent, and accountable. Thank you, Mr. Chair. I'll stand for any questions.
Thank you, Sheriff. We have Ms. Ramsey here to testify from the ACLU. Go ahead.
Thank you, Chair and members of the committee. Again, my name is Alicia Granzi from the American Civil Liberties Union, and I had the opportunity to speak with Senator Dibble and the association about some of the concerns that brought these changes to our bill or our previous legislative efforts around UAVs. And after speaking with them, I think that we could potentially come to some agreement on language. Right now, as it stands, we believe that the preservation or protection of evidence clause as amended is still a little bit broad. But again, I have now understood some concerns from the sheriffs about what they're looking to do with this. So I think that we could potentially have an opportunity to come up with some different language. We do not object to a private citizen certainly asking for assistance and giving written consent. So page 2, line 1, that we don't have any objection to that. Again, as drones become used more and more across the state, we just want to make sure that, this powerful tool has the right limits to protect people's civil liberties. So thank you for the opportunity to testify.
So, Mr. Chair, in responding to the ACLU and the concerns they've raised, I think the interest is in, creating some more clarification or some qualifications for what you'd find on line 1.4 of the A3 amendment, which I would very much be interested in doing because I respect the perspective of the ACLU very much. I don't know what your intention is. I think it's to lay over the bill. I don't know if you're inclined to allow for that work to occur before it's taken up again, either in an omnibus bill or as a separate discussion, but that would be my intention, is to take the next few days to work out this conversation.
Yes, thank you, Senator Dibble. It is our intent to lay the bill over for possible inclusion, so there'll be further opportunity to work on language. I do have a question. We heard a UAV bill earlier today that dealt with exigent circumstances, a person fleeing law enforcement, and I just wanted to make sure that what is proposed here and what we did there don't interfere with or conflict with each other. And I guess maybe the only place that conflict might come up is with the written consent requirement for a private area. So I guess my question, maybe it's for council, is whether or not the proposed written consent person that's only for training or public relations purposes. is proposed here. So as I'm reading it, it might not have any impact on tracking down a fleeing suspect. Sheriff, is locating cattle somewhere out in a cornfield, would that be for public relations purposes or training purposes? Is
Mr.
that
Chair, it
intent
would.
there?
It would.
Or it would be used for those purposes anyway?
That's correct.
I'm a little bit concerned about just putting public resources out there for use at the request of any private citizen who wants to use it for whatever their purpose is, and if they can convince the sheriff, my friend, neighbor, sheriff so-and-so, to send out a drone because I need to get this or that done in my private purposes.
So
how do we draw that line, Sheriff?
Yeah, so of course, it's on a case-by-case basis, and as resources are available, including time and equipment, but we as a course of practice do everything we can to encourage those positive interactions between the sheriff's office and the community that we serve. And so if we can take advantage of situations like that, where maybe if we don't respond to that, those cattle are going to end up on a roadway, somebody's going to hit them, somebody's going to get hurt. So in a case like this, I don't think we would think twice about doing everything we can to at least help out.
Good segue, Sheriff.
Mr. Chair, I'm wondering if
Senator Dibble.
drones can get kittens out of trees.
Might provide valuable training for the drone operator. All right, anyone else in the room want to testify on this bill? Any questions or discussion from committee members? I'm not seeing any, so at this point, we'll just lay Senate File 1524 over for possible inclusion in the omnibus bill. Thank you. Senator Dibble, I understand your amendments on your other bill are ready to go, so we'll take up Senate File 1920. Staff are distributing the bill and the amendment to the committee. This is the first stop for the bill. There's an A1 amendment as an author's amendment. Senator Westland moves adoption of the A1 author's amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Dibble, tell us about your bill. Members, the intent here is to lay this bill over as well.
Thank you, Mr. Chair, and members, for the opportunity to present Senate File 1920. And it has to do with a couple of circumstances that arise when folks are under guardianship. The first is a concern around the restriction of visits from family members with persons who are subject to guardianship. And the proposal, simply put, is to ensure that, or if you will, shift the burden, if you will, from those who have been denied the opportunity to visit their loved one, which under current circumstances is up to them to overcome that guardian's decision to deny that visit, to require a more proactive action on the part of the guardian to provide that rationale for the reason that the visit has been restricted. And so it provides, it's a burden shifting, and it provides some process by which the guardian can make the case that that person's visitation represents some sort of negative consequence for the person under guardianship. And I will let Ms. Scheller explain in more detail how that works. And then, of course, we have some language that further modifies that's come about through the conversation with folks who have varying perspectives on this matter, and that's reflected in the A1. And I'll have Ms. Scheller explain the nature of those conversations and how the A1 responds to those conversations. The second issue is in the case of appointing guardians an emergency basis. And when that happens, under current law, there is little or no requirement that the person subject to guardianship or persons who will be interested in that person's being placed under guardianship be notified. And there's a lack of clarity on the thresholds that must be met in order to do so, particularly when a care facility petitions for that emergency appointment of guardianship. There are often very, very good reasons, and that's well and fine, but the solution, but the due process concerns are fairly substantial. And so the solution that has been proposed is that notice, in fact, do be given, and as well as to interested persons. There is, of course, a presumption that, if a person is in a care facility, they're receiving care. That would be a rebuttable presumption, of course, but the idea here is to gain more clarification for those emergency appointments. Again, there's been some discussion with folks who have a different perspective, so there's some modification of that in order to allow for the timely appointment of emergency guardianship, and then, of course, requiring the hearing to occur to affirm that appointment within a timely basis as well. I think, and Ms. Scheller can help, this amendment was created with the incredible and fast work of counsel, Ms. Brimo, but there might be some tweaks needed. I think we'll also have the opportunity to lay this bill over and further refine the language in the coming days, if that's acceptable to the chair. With that, Mr. Chair, Susie Scheller is here from Elder Voices, who can help clarify more about why this bill is before us. Thank you, Mr. Chair.
Ms. Scheller, welcome to the committee.
Thank you. Thank you, Chair Latz and members of the committee. My name is Suzanne Scheller, and I'm the legal advisor for Elder Voice Advocates, and we work to promote quality long-term care for vulnerable adults. We receive calls and emails daily, and this has been a particular concern related to the guardianship matters before you. And so it is not based on infrequent scenarios that play out for those subject to guardianship and their families. And so in this particular bill, the essence of the bill is twofold. One, as to visitation restrictions. Right now, a guardian could impose the restrictions, and it would be the responsibility of the person who has the restrictions on the visitation to go to the court to ask for a modification of restrictions. And so we are looking at burden shifting that, as Senator Dibble mentioned, to have the guardian make some finding or threshold to the court before the restriction. Now, one of the things that you will see in the amendment is some modifications to that, and those are all good. We're receiving, we see this as a discussion, and we're in contact with stakeholders and receiving feedback, and that's partly what's in the amendment. But the essence of the visitation is something where Senator Westrom has identified this, and other legislatures where they have constituents that they're not able to visit their loved one even in their final days. And so in one particular example, two very close siblings were separated in their 80s when the guardian prohibited visitation. We attempted supervised visits and some communication that would not have been in person, but those alternatives were not responded to. Finally, a modification on the restriction was sought with the court. Unfortunately, over 45 days later, while still awaiting the court's ruling on that modification, the sister passed away without the sibling even knowing about the death. And so we were trying to work with the guardian on that, and were unsuccessful. And this story plays out similarly frequently. There was another call just this week, a child being restricted from visiting their parent on hospice and wondering if they're ever going to know, even when they pass away or when their last breaths are. So it is significant. We recognize there's reasons to restrict visitation, and that's why in the amendment, we see that a person could restrict a visitation under some threshold findings, and that if there is a hearing by the guardian to restrict, then we're asking the court to hear that within 5 days, some type of time limit, so that we're not left in ambiguity on the restriction for a period of time. So that is in your amendment. As to the due process in the appointment of emergency guardianship matter, we are seeing this related to sometimes hospitals or facilities petitioning for an emergency guardian appointment without the person even knowing about that, when there is clear knowledge of where the person is and notification could be made that an emergency guardian appointment is being sought for that person. So the concept was to try to ensure due process when you have the ability to notify the proposed person subject to guardianship of the emergency hearing, please do so. And also the backdrop of that is if an emergency guardian is appointed, it is much easier for a permanent guardian to be appointed, which sets down a different path. In your amendment, you will see the stricken language restored, but you will also see language that there must be good faith efforts made to provide notice to the proposed person subject to guardianship, also the respondent, called the respondent or the respondent's attorney. So we're again trying to balance that between when we know we have an emergency and need to have an emergency guardian appointed, but yet not yet notifying the proposed person subject to guardianship and making good faith efforts to do so. So those are the essence of the original and the amendments before you. And I'm happy to answer questions or provide further information. Thank you.
Thank you, Ms. Scheller. Any questions for Ms. Scheller? Senator Kroon? Or on the bill? Senator Kroon.
Thank you, Mr. Chair. So in the A1 amendment, it restores the stricken language on 3.22 to 3.28. But on line 3.19, the except as otherwise provided in paragraph B is still stricken. Is that intentional or is that an oversight?
Ms. Scheller or Senator Dibble?
Yes, I see at 3 point, excuse me.
Ms. Scheller.
Yes, Mr. Chair, Senator Kroon, 3.19 has not been modified in the amendment. We just got this amendment here. We are still looking at some tweaks, so that likely would be something that would be unstricken, I guess, if you will, because if we restore the language of Part B, then we have Part B. So, yes.
Senator Kroon.
Thank you, Mr. Chair. I think maybe I'm missing it, but in the A1, I don't see that language restored, and it sounds like it should be. Am I missing something, Council?
Ms. Primo.
Mr. Chair and members, that is an oversight on my part, and yes, it should be restored.
Senator Kroon.
Well,
You have a motion to restore the language?
Yeah, Mr. Chair, I'll make an oral motion to restore the language that's stricken in line 3.19, however that's supposed to be worded. I'll rely on Senate Counsel for that.
Ms. Primo, will you please restate the amendment then for the committee?
Mr. Chair and members, page 3, line 19, reinstate the stricken language.
Any further discussion? Senator Dibble, your position.
I would support the oral Kroon motion to amend.
All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Any further discussion? Senator Kroon.
Thank you, Mr. Chair. Going back to page 3, this in 3.21, the addition of interested parties there. Is that defined somewhere else, or how is the movement supposed to know exactly who the interested parties are in that section?
Senator Dibble. Ms. Scheller.
Yes. Chair Latz, Senator Kroon, yes, that is a defined and known term within, and I don't have the site for you to point back to it. I can get back to you on that. But it is, the idea is there a healthcare agent appointed? Is there, sometimes are they in a facility, and is the facility aware of this emergency appointment? So there is some definition in law and concept of interested parties.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. And I don't know where that is, but maybe there should be a cross-reference there, unless it's obvious in this context. I'm not real familiar at all with this area of law, so it just seems like in the real estate concept, which is I'm used to, it's usually people that have a recorded interest, something that somebody can rely on. So I just wanted to make sure that the person knew who to serve. It sounds like they do. Whether or not a cross-reference is warranted, I guess I can leave that for you to ponder as this gets laid over. Thanks.
Any further discussion? Anyone else in the room want to testify? Senator Dibble, any closing remarks before we lay it over?
No, thank you, Mr. Chair and members. It may come to your attention, that we have a task force that's working on these issues. The task force is set to convey their report and findings in 2027. In the meantime, we have these circumstances that exist in the real world that Ms. Scheller described. And so, tending to some of these matters in the meantime, continues to have some urgency and importance. But I will say that conversations, really productive conversations occur among all stakeholders, both the consumer advocates as well as those who represent institutions and guardians, to make sure that we get it right. So I appreciate the opportunity to hear 1920. There may be some tweaks similar to the drone bill that we just heard before this lands, if it should land in your omnibus bill. So if you're open to receiving some of that information outside of this venue, I'd be most appreciative of that.
With that said, Senate File 1920 is laid over for possible inclusion. Thank you, Senator.
Thank you, Mr. Chair and members.
Okay, we're going to go to Senate File 1063. Senator Marty and Senator Pa apparently are presenting this together. So we have the senators come forward. Senator Marty.
Thank you, Mr. Chair, members of the committee. We are here to present Senate File 1063, and we have an A3 delete everything amendment, which I believe is in your packets.
Members, this is the first stop for the bill. This will be in the nature of an author's amendment. Senator Limmer, would you like to be the author of the author's amendment? Senator Limmer moves adoption of the A3. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment's adopted. Senator Marty.
Thank you, Mr. Chair. Homeowners Association, or HOAs, are now, I believe, 83%. Senator Pa tells me 83% of all new housing is in HOAs. About a third of national housing stock now is part of it, but of new housing, almost all of it is. And there's many problems with this. I think many of you are aware of that. Fortunately, we've had some progress in beginning to address this. There's a bipartisan HOA task force working on this, and they've put together a very helpful bill. I'm here with Senator Pa, who she and Senator Lucero are serving on the task force. And they have also another bill, Senate File 1750, which is Senator Lucero's bill, which has many of the recommendations from there. This bill was off to the side of it, partly because this has a cost. This would be going through the commerce budget, and we believe we will have revenue neutral in the first biennium. But we'll get to that. The reason we're here together is half this bill, the registration of CICs, was a bill from Senator Pa, and the Common Interest Community Ombudsman was my bill, and we're combining them. Senator Pa will be the eventual author of this, but we want to make sure that we address some of the concerns. And And I will note that rather than bring in witnesses, we have a packet of people writing very thoughtful letters on this. I would just call out the Homeownership Minnesota one, which very conveniently summarizes the benefits of both parts of this bill. I'm going to speak to the ombudsman part of the bill. It gives several responsibilities. One is to assist homeowners in their disputes with HOAs. Often these are people who have, it's kind of a one small entity against the huge entity that has often had problems that the task force has come across, such as conflict of interest and the repair work being done and so on. But anyway, the first step, this would be responsible for assisting homeowners in their disputes, would also provide dispute resolution and mediation services in disputes, would also provide assistance and information to HOA boards, many of whom are purely volunteer members of small things. They don't have management company or anything. They often don't know the law. And we want to make sure that the ombudsman provides assistance to the boards, the homeowners, and renters of the owners in understanding the laws, rights, and responsibilities. This bill is very similar to the role of the ombudsman for long-term care. The only difference is that this ombudsman would not only be assisting the homeowners in this case and providing dispute resolution services, but this one would also be providing information to everyone involved, the homeowners, the associations, and everyone. Funding for this would come from the HOA registration language Senator Pa has developed, and given that there are about 8,000 homeowner associations in Minnesota, and the initial fiscal note on the bill, I have a feeling we would be guessing the registration fee, depending on the size, but the average would have to be about $100, which is not a huge fee for some of these entities, but we're working on that. I will go through the section by section, the Article 1 quickly, and then turn it over to Senator Pa. After the definitions, we would be establishing on page 1, line 15, be establishing ombuds position in Department of Commerce to assist unit owners in enforcing rights and to facilitate dispute resolution. Then the duties under at the bottom of the page be to create the first one. A lot of this came from the task force that's been working the last year or two, creating and publishing plain language explanations of provisions and declarations and bylaws, which is a huge problem for a lot of people who aren't familiar with this. Publishing materials providing resources and referrals related to rights and responsibilities. And upon a request of a unit owner or an association, provide dispute resolution services. They are not an arbitrator. They have no authority to make decisions. And then the ombudsman may provide dispute resolution for disputes between a tenant and an association if the unit owner agrees to participate in the resolution process. And under paragraph D, the ombudsman must compile and analyze complaints against the communities made by unit owners in order to identify issues and trends, which would be very helpful to the legislature in looking at problems still existing. And when they're assisting a unit owner, they could help them within data practices rules, could help them find out the existence of other complaints if that would be helpful to them. The website, the ombudsman must contain a website with the law, information providing the services the ombudsperson does, and information about alternative dispute resolution methods and any other information helpful. And they would be required to report to the legislature as appropriate, and they may at reasonable times enter review premises in help with the dispute resolution. We limit the powers at the top of page 3. They are not able to make any formal legal opinions. They're not able to solve disputes. They're supposed to bring people together. And we require people to cooperate with the process, make good faith efforts. What that does, I'm not sure if it does a lot, but we're asking everyone to be involved. And data is, I think this is standard. We'd be keeping it private data on individuals or non-public data. And that's it for this article, except for the appropriation, which would be handled in the other committee if this goes forward. And with that, I'll turn it over to Senator Pa, who authored the second half of this, and thank you for your attention.
Senator Pa.
Thank you, Chair, and thank you, Senator Marty, for explaining the bill. I appreciate that. Chair Latz and committee members, Minnesota has approximately 7,950 common interest community associations, impacting over 1.5 million homeowners in the state of Minnesota who live under HOA governance. This is a bipartisan bill in the Senate and in the House. It has strong backing from the 20-member legislative working group on common interest communities. Establishing an ombudsperson is one of the key recommendations that came out of that work. HOAs wield enormous power, setting rules, levying fines, and even initiating foreclosures. Yet they operate with very little oversight and often without the basic transparency that we expect from any governing body. That's why this bill is such an important bill for us to pass this year. It has broad support from stakeholders and constituents because of the urgent need for some type of oversight. Members and Chair, I encourage you to please support this bill, and we're open for questions.
We'll move to questions from members. Senator Limmer.
Thank you, Madam Chair. Senator Marty, if I could direct your attention to page 4. Page 4, line 4. Under the establishment clause, it says the Department of Commerce must establish a register that contains information. What information are we defining?
Madam Chair, Senator Limmer, Senator Pa is the author of this provision of it, and it does list what they're required to have there in paragraph.
Senator Limmer, thank you for that question. So the Department of Commerce must establish a register that contains the information that we've listed in section subdivision 3 for each of the common interest community. Previous to, or I would say currently now, there is no requirement for common interest communities, HOAs, to list their information where people can actually access it. All organizations must register with the Office of Secretary of State, but there's no way to search that database to find out who is actually the owner of an association, or the association's information, I should say. And so let's say, for an example, if I wanted to buy a unit in a certain association and I wanted to contact the association first for their bylaws, there's no way for me to find out who that association is unless they listed publicly, which some of them do not list any other sites besides Office of Secretary of State. So this would require that they must register.
Madam Chair,
Senator Limmer.
I happen to be a real estate agent in real life, and I've had the same difficulty with clients when we're trying to get information regarding the homeowner association. Mm-hmm. Sometimes just simple questions need to be resolved before entering into a purchase agreement. Now, when one does enter into an agreed-upon purchase agreement, then the CIC requirement for sale information kicks in. Then the seller has to provide the potential buyer with all of the information that you're listing here, but it does not require a phone number. And sometimes you just want to make a simple question to a homeowner association, and there's no number to be found. Even if you read through the entire 300 pages of declarations and corporations and other information, rules and regulations, even when they say you must report to the homeowner association, there's no contact direction even in that. So, and I've certainly read through a number of those 300 pages on a variety of purchases. But There, in line 4.14, it talks about requiring a telephone number. Is there a requirement that someone has to answer? Because I've also run into other situations where you can call the homeowner association with a number, or the property management company that's under legal binding to represent the HOA. You can call that phone number, and I know of some companies that will never pick up the phone. And it's really at the detriment of the consumer, and it certainly doesn't represent the HOA well either. So I don't know if we can require someone to pick up the phone when it rings, but that really is an issue that is very difficult to get information out of organizations. It's, I probably can go on and on this, but there needs to be some way to contact individuals. It should be a responsibility of someone. Oh, by the way, while I'm at it, I've often looked up the corporation data from the Secretary of State's office. And when I look that up, now that usually is created at the beginning of the development. But when you contact and look up the nonprofit organization that represents the HOA, it's in the owner's name, or the contact name is in the name of the Property Management Corporation. And somehow they've finagled their name in as the contact owner of the corporation, and there's still no phone number. So you're just in a constant circle looking for information on behalf of a consumer. Thank you.
Senator Marty.
Mr. Chair, both Senator Limmer and Senator Pa are realtors, and I'm sure come across this a lot more than the rest of us do. But yes, I think the telephone number, which we do require, but I think it's a good point to telephone number that's just there and it just rings. You know, the message can't take further messages and nobody returns the calls. It's a worthless thing. I think we should be exploring if there's a way to make it more meaningful. And I think having the registration at Department of Commerce, having an ombudsperson for this, if people are having that issue, I mean, we may figure out a better way that they have to have a responsive thing. So I think it's a good point, and we can look at that further.
Senator Kroon.
Thank you, Mr. Chair. On page 4, 4.4, in the establishment provision of the registration, it says that the Department of Commerce must establish a register that contains information regarding the CIC. What is information in that context? Is that reference down to the information in subdivision 3B? Is that the exact information?
Senator Marty, or Senator Pa.
Chair, yes, Senator Kroon, that is correct.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. I'm just wondering from a drafting standpoint if it makes sense to add in line 4.4 information as described in subdivision 3B, just for clarification.
Mr. Chair, it sounds like a good
Senator
suggestion.
Marty.
And maybe Ms. Primo can.
Ms. Primo, any suggestions?
Yeah.
Mr. Chair and members, page 4, line 4, before information, insert the, after information, insert required under subdivision 3.
Senator Marty?
Looks good to us.
Senator Pa?
Yes, that's a great suggestion. Thank you, Chair.
Senator Kroon so moves. Senator Kroon? Any discussion? All those in favor say aye. Aye. Opposed? Motion prevails. The amendment's adopted. Senator Kroon.
Thank you, Mr. Chair. Then one, I don't know if it's a concern or a question, but on page 1, 1.26 in the duties provision of the ombudsperson, it says that they must assist unit owners, their tenants and associations to understand and enforce their rights under the chapter and the governing documents. But then on page 3 in the limitation of powers, 3.1, 3.2, the ombudsperson is prohibited from rendering a formal legal opinion regarding a dispute between a unit owner and an association, which is appropriate. But it seems to me like most of the inquiries are going to be related to a dispute. So just wondering your general thoughts on how an ombudsperson is supposed to comply with their duties to help unit owners, tenants, and associations to understand and enforce their rights without rendering a legal opinion.
Senator Marty.
Mr. Chairman, Senator Kuhn, the stuff at the top of page 3 is in their dispute process. I mean, in other words, they're supposed to assist them in understanding the law. And I think one of the reasons we want to make sure it's not just providing the homeowners with this, but also the associations, is some of these associations have huge management companies and lawyers and everything else. Some of them are small entities, maybe 8 townhomes or something, and they're all other residents, and they don't really have any clue of the law or anything else. And I don't think spelling out, explaining the law and assisting them in understanding their rights and so on I don't think that's not rendering a legal opinion. That's saying, here's what the law says. I presume helping them understand what the law says and so on as well. But I see that as different than, in other words, we want to make it clear this is mediation, not arbitration kind of thing.
Senator Kroon.
Thank you, Mr. Chair. I see what you're saying, and I think that's reasonable. I just think it's a fine line that the ombudsperson's going to have to walk.
Right.
And I hope they're skilled in doing that, although I will say, if this passes, this might be the most miserable job to have in Minnesota. So hopefully somebody applies for it. Thank you.
Everyone's got a horror story in this space. Okay, we still have a couple testifiers that have been waiting patiently. So what I'd like to do is invite our testifiers to speak, and then we'll circle back to further committee discussion, okay? So our first testifier is Becky Cole, who is online. Ms. Cole, welcome to the Senate Judiciary and Public Safety Committee.
Thank you, Mr. Chair and members, for this opportunity to testify. And I apologize, my cat thinks Zoom is made for him. My name is Becky Cole. I'm an HOA homeowner, and I'm here to support the creation of the Office of Ombudsman for Homeowners. What we as homeowners need is a place to go where we can ask questions and get answers from a reliable, credible source. But currently, we're at the mercy of management companies and others who don't always provide a complete or truthful basis for their information. We also often get punished for asking questions, too. For example, when I asked the insurance company about the conflict of interest we have in allowing first service residential to be covered on our insurance, I ended up with a phone call from the police because they were trying to get a restraining order on me to get me to stop asking questions. CAI calls this industry standard, but you won't hear them call it wrong. When I asked our board to consider changing management companies, I got a letter from Nancy Palomas. She's a lawyer with Helmuth & Johnson on behalf of First Service Residential, telling me I'm not allowed to contact the board. If I have anything to say, I need to send a snail mail to First Service, and they will decide whether or not the board sees it. Using attorneys for controlling homeowners who are also footing the bill for the attorney to do something like that is also something you won't hear anyone in management or trade associations say that it's wrong to do. Our CCRs state that board members are to be voted in by homeowners. Our board chair has never been on the ballot, and on our business registration with the Secretary of State, the Office for Service is listed as the president of the association. I have nowhere to go to get honest, truthful answers about how or why that happened either. CAI's tactics are to teach board members and management companies to be dismissive and downplay the experiences of homeowners, or use bullying and threats to avoid having to answer questions that aren't convenient for them to answer. But as Senator Draheim said, if they wanted things better, we wouldn't need the legislature to make things happen. One of the questions I'm not allowed to ask is where are my and many other associations' bank accounts? They're not in Minnesota. Our primary account is in Iowa. We send our payments to South Carolina. There's another one that sends their money to Florida. Why are our banks not in Minnesota if our business is registered in Minnesota? Why is that not happening? Another question is if Centex is on the Articles of Incorporation, then why are they not responsible for the conduct of the board and the management company? However, the bigger question I have that tends to make people scatter is why is this business model that municipalities use allowed to strip homeowners of their civil rights and this be the only business model municipalities are choosing to use to implement HOAs in the first place? Please don't buy into any board, municipality, or trade association's victimhood nonsense. And remember that HOAs are a business, and yet they are also not legally required. If they can't be run with sane, sound business practices with accountability for their conduct, just like every other business, then the Ombudsman's office is a great place where we should be able to gather information to begin a receivership or full dissolution process. We shouldn't be told to tolerate toxic business practices because changing things would be inconvenient for those who are taking advantage of us. Also, we don't want another place where things go to die. We have enough places like that already. Without some enforcement path or regulatory authority involved that can be handed off to or referred to or make sure that they are getting involved, then that's what's going to happen. The purpose of this isn't going to change things because we are already being taken advantage of, and we need something better. The Community Association Institute calls what is happening to us the industry standard. It's time for a new industry standard that recognizes that homeowners matter. Thank you, and I'm open for questions.
Thank you, Ms. Cole, for your testimony today. Do any members of the committee have questions for Ms. Cole? I'm not seeing any. Thank you. You're welcome to stay online and observe the rest of the proceedings if you wish. We also have testimony from Patrick Hines. Mr. Hines, come on forward. If you'd go ahead and identify yourself and your affiliation and proceed with your testimony.
Thank you, Mr. Chair and members. For the record, my name is Patrick Hines with Messerly Kramer. I'm here on behalf of the Minnesota chapter of the Community Associations Institute, which represents the interests of homeowner associations. Our members include residents, board members, and business partners such as property management companies, attorneys, contractors, and really anyone who does frequent business with homeowner associations. I want to thank Senator Marty and Senator Pott for bringing this bill forward. There's been a lot of discussion about HOAs this session, and CAI does support the creation of an ombudsperson. If it's done in a way that makes sense for both associations, their board members, and residents, I greatly appreciate Senator Marty's comments, reminding people that while we refer to associations oftentimes the same way we refer to corporations or departments, they are simply, the board members are simply residents of the association who volunteer their time to help their community. They are subject to the same rules and regulations as all their neighbors. They pay the same monthly dues and special assessments, and if they break the rules, they pay the same fines. So it's not a large entity that generates revenue. All of its revenue, if you could call it that, are monthly dues that residents pay to pay their bills. So I think that's always important to keep in mind when we're talking about regulating them. Looking at the A3 amendment, I think it's a significant improvement from the bill as introduced, most importantly because it does allow board members to go to an ombudsperson and say, we need help dealing with a dispute. We need help because we have an upset resident and we don't know what to do, or we are trying to resolve a dispute between multiple residents and we don't know what to do. So I think that's a great, that's a model that CAI can support. I think there are, some changes that we would still like to see. For instance, on line 2.14 through 2.18, again, it's talking about complaints by residents against associations. I think that the ombudsperson should, if they're going to compile complaints, they should also analyze the complaints that board members might give about dealing with residents. I think that's just part of being balanced, and I think that data would be equally useful. I think that my hope is that at some time in the not-too-distant future, this session, I'll sit up at the committee table with stakeholders from another group and say that we have a bill that we support and that will help us and hopefully help the legislature in dealing with the many questions that arise from HOAs and the disputes. If I could address, there's a couple of statements that were made during the discussion. Again, there are many associations who don't have a management company. If we're talking about providing phone numbers for an association and requiring people to answer their phones, we're talking about people, residents, homeowners. So if I were the president of the board, it would be my personal cell phone that I am required to answer. I think that is going to make life difficult for board members. And many of you know it is very difficult to get volunteers to be on boards. So I would just be careful about putting too many requirements on board members. I think there are other ways to go about getting that information if you're looking for this into the sale or purchase of a property. And I didn't comment on Article 2. We have met with we, Community Associations Institute, has met with the Secretary of State's office multiple times to discuss this issue. As was noted, associations are nonprofit corporations. They're therefore required to renew their registration with the Secretary of State every year. We've always hoped that there would be a way that all associations are noted as being homeowner associations as opposed to any other nonprofit corporation. It would make it easier to gather data about the number of them and any other issues. I think the important language is on page 5.19 through 2.1. That's the data classification. If we're going to require board members' contact information to be submitted to the state, I think it has to be private data on individuals, and I see that in the bill, and I'm very happy to see that. I think the enforcement provisions in subdivision 6 may be a little harsh when we're talking about associations who are volunteer board members, but and then finally, the registration fee. I know we don't know exactly what that fee would be. Again, the only place that money is coming from are the residents of the association. If the homeowners association has to pay X amount of dollars, that money comes from the residents. So if it's $1 a resident, probably not that big a deal. Depending on how high it gets, I think that could be problematic. So thank you very much for the time today. I'm happy to answer any questions.
Thank you, Mr. Hines. Any questions from Mr. Hines at this time? Senator Pappas.
Thank you so much, Mr. Chairman. So ironically, my HOA had their monthly board meeting last night, and I attended. And I think one of the problems is how homeowners communicate with their board. And in this bill, you require that they have to make publicly available their email addresses, blah, blah, blah. But with my board, they don't answer their emails. They get kind of overwhelmed with so many emails, evidently, is what they told me. So I'm just wondering if, I'm kind of talking off the top of my head here, is one of the owners suggested, well, can we have like, interactive website where owners can post their questions, because they could be repetitive ones, and then the board members could respond that way, some kind of a communication interaction. And my association, which has been taken over by some uncooperative people, just kind of dismissed that. They don't want to have to deal with that. So I need an ombudsperson to help me out here with, how you deal with kind of an uncooperative board until the next election, which is next January, that refuses to communicate with the owners. And so it's not actually the management company that's the problem. It's the actual board that was elected by the members. I suppose you could argue that elected officials, too, maybe don't always respond to their constituents.
Don't cast
So if you
that
have any
aspersion too
suggestions,
widely.
maybe how other homeowner associations have what kind of systems they might have for kind of interactive communication, I'd be really interested.
Mr. Hines, do you?
Or anyone.
Senator Pott, then I know there's at least one member of the public wishes to testify as well. Senator Pott.
Thank you, Chair Latz. Senator Pappas, those are really great comments, and that's exactly why we need this bill, and the bill that will be coming before this committee, hopefully soon, which is the 1750 Lucero bill. That is our big HOA policy bill. We have heard from homeowners association homeowners throughout the state that said exactly what you said. We have to get a hold of the homeowners association. They don't pick up their phone. They don't answer emails, and it's something urgent, and we need a reply. How do we get in communication? Some of them don't even have an email to. I mean, there really is no contact information. And so that's why this bill, having an ombudsperson to be able to provide some guidance, whether it's resources for homeowners associations, especially smaller ones, or referrals, or some type of advocacy for homeowners would be great. Because right now, we do need people to understand that when you establish a homeowners association, there are responsibilities to that. And one of them is answering to your homeowners who actually contact you for something. And so, but homeowners associations are welcome to establish websites or any other means of communication, but they should also be able to have a way for their homeowners to contact them for something that's urgent or of a legal matter. If you're being slapped with a $500 fee or fine for something and you are disputing that, if you have no way of contacting the homeowners association, how are you going to ever talk about why you're disputing that fine? Yeah.
There is one member of the public wishes to testify as well. It's at least, sir, come on down. Then we'll ask if there's anyone else who wants to testify, and then we'll continue with committee discussion. Sir, welcome to the Judiciary Committee. If you'd like to identify yourself for the record, please state any affiliation that you have and let us know what you'd like to say.
Hello, everybody. My name is Rick Heller. Unofficially represent twice exceptional Minnesota Statute 120B15 and print disability in 2025, Senate File 1703. I'm a white male with a beard and a camouflage hat with red suspenders for the public that can't see. Come to testify on this 1063 bill. I did speak twice at your working group meeting. One of the things I brought up about considering setting the text complexity of their contracts. Also applying digital accessibility like the legislature did in 2019, thanks to Marty. He was on the 1727 bill to apply digital accessibility to the legislature. Regarding the text complexity, in 2015 and 16, the legislature asked the Minnesota Department of Education to set the text complexity of special education forms. I waited 3 years, but I did my data request. Obviously, they did decide to work with the University of Minnesota, as stated on their landing page, for due process forms, but do not express what metric they use. They're using the Lexile metric, which is our national metric now based on frequency of vocabulary word, length of sentence. Decided to go with 8th grade. And they also mentioned they did for people with reading disabilities. However, it was the teachers union who also aggrieved with this process back then as well. So think about text complexity of contracts, think of glossaries, think about Osmond, how they're setting their text complexity for these individuals. I think it's all relevant as people want a little ownership to understand. I did hear that word. It takes 98, 99% word recognition to understand content, very high level. Those are my suggestions today. I have not studied this bill in Pacific, but my spoken word is on those meetings. And I guess we'll go from there. Thank you for this opportunity to speak.
Thank you, Mr. Keller. Any questions for Mr. Keller from members of the committee?
If I may correct, it's Heller, H-E-L-L-E-R. Thank you, sir.
Oh, I'm sorry. Thank you, Mr. Heller. Got it. Anyone else in the room wish to testify on this bill? All right, let's continue with committee discussion. Senator Howe?
Thank you, Mr. Chair. You know, looking through the number of packet of letters, I just found it odd that cities actually require HOAs to be, you know, to me, that should be between the developer and the homeowners that are buying it. And if the homeowners decide to develop an HOA, nowhere do I believe that a city should be requiring HOAs to be formed. My only other, you know, I've dealt with them on a professional basis in my other career, but the other place I've dealt with them is my son's HOA. And they were having a bunch of issues. So what they did is they just got together, and when the elections came, they took the board over. Now they've solved their issue. So that's the good thing about having an election on HOAs. You do have the opportunity to control, and now the biggest problem is the former president of the HOA doesn't get her roof fixed, doesn't take, she's not abiding by the agreement. So there are avenues for these folks to do it if they just participate, but most of them don't participate in the process. And much like I think our constituents out here of our own districts don't participate in the process. And I think that's where the biggest problem. I'm concerned that I'm a little concerned of the process we're going to, and I would like us to maybe go down that road, and maybe that's in the other bill that's coming to actually dictate what HOAs should do and how they should do it. You know, my input on ombudsperson is I don't know how this one was drafted. The best one I know of right now is the format that they have at the Department of Revenue, because everyone I've sent to the Department of Revenue ombudsperson, they have gotten a positive outcome. And that can't be said for a lot of the ombudsman people that are out there. So if you have not looked at how that is constructed and how they operate, I would strongly suggest to follow how they're put together. Thank you.
Any further questions or discussion from members of the committee? Senator Carlson.
Thank you, Mr. Chair. And I guess I want to thank Senator Pa and Senator Marty for bringing this bill forward. In my world of complaints, I don't think I've gotten any more focused complaints than I have about HOAs. And this kind of thing is really, you know, an ombudsman at least can take some of my email away. But I have gotten to know just a bit Ms. Cole over email, and she is quite an advocate. And I think we do need to work on some things that, especially this communication issue of being able to get communication, and you know, not everybody can handle a new vote. There might be disabled people that they just don't have the same kind of oomph than another person has, but they still are owners, and they still need the help that everybody else does. I have had situations where, for instance, a board, or let's say, I'm not sure if it was the president of the board or the board, was mandating some parking restrictions and mandating putting that each resident put their name, address, phone number on the dashboard of their car, and that's going to be their parking permit. And to overcome that, I had to get the police chief and the mayor involved in this city to say that you don't want to put people's name and address on their dashboard, because if the car is not there, maybe that's an open invitation for someone to come in and clean out their abode. So lots of little things like this, I think, and the complaints sometimes are easy to understand, but they're hard to resolve. And I have one friend who is the president of an HOA, and he's absolutely thrilled to be president, and I think he works hard on behalf of his neighbors, but that's not all of them. So thank you for doing this. I really appreciate it.
I think this committee needs an ombudsman for our HOA experiences. I will simply encourage people who buy property subject to an HOA to get involved in your homeowners association. Some of these problems would go away if people paid more attention and got involved. And it's the association that affects probably your largest single asset, or in many cases, that's the situation. So with that said, the motion to be brought by Senator Westland is that Senate File 1063 be recommended to pass and be re-referred to the Senate Committee on Commerce.
As amended.
As amended.
Mr. Chair,
Senator Marty.
I thought it was going to state and local first, but I'll ask Ms. Kaplan to correct me if I'm.
Apparently Commerce has requested it first. Were you aware of that?
If she would know better than us.
Okay, apparently you're going to Commerce first.
Okay.
All those in favor say aye. Aye. Opposed? Motion prevails. Thank you, Senator Pa. Senator Marty, we got another bill of yours here, Senate File 1163, which we're going to take up. Members, the intention is to lay this bill over at the conclusion of our proceedings here today. The bill is being distributed. This is the first stop on the bill. I'm not aware of any author's amendments to offer at this time. We have Senator Marty, if you want to give us a brief description of the bill.
Sure.
And then we've got a couple testifiers coming forward as well.
And I will
Senator Marty.
be brief, Mr. Chair, because I know your schedule is so long. This bill, Senate File 1163, would create an Office of Animal Protection. Minnesota has no coordinated approach of any kind to addressing animal cruelty, which is a serious and a very complex problem. It's a public safety issue, both in the clear connection between the fact that people who abuse animals go on, and it sort of, I don't know if stepping stone, but it's a way towards other types of crimes of violence. And number two, it's used as a tool in many types of abuse, domestic abuse and so on. It's harmful both to animals and to people. We want to create an Office of Animal Protection, so there's a state office that's taking a look at this, helping coordinate efforts with local law enforcement and prosecutors who have need someone to turn to, learn from, will coordinate things with, also to educate public and to prevent animal abuse, which is the goal. Because of the budget challenges, we realize that this bill is not moving forward. I would like to, before we have the testifiers, mention that I would hope that the committee would at least take consideration of Section 7 for your omnibus bill, which would make felony violations of animal cruelty into a crime of violence. I hope you will take a look at that specifically, but we have two witnesses here today. And I also wanted to say that in the packet, we have a number of letters in support of this. I'll highlight one from Corner House, which is apparently a child advocacy center in Minneapolis for children who are exposed to trauma and violence. And they talk about how often children have victimization where they're experiencing domestic abuse and animal abuse, and they use the animals in a way to psychologically damage a child or manipulate a partner. And they talk, it's an eloquent letter about that. There are many other powerful ones, but with that, I'll turn it over to the two witnesses.
All right, which of your testifiers would like to go first, Senator Marty? Go ahead and identify yourself for the record.
Thank you, Mr. Chair, committee members. My name is Reese Fredrickson. I serve as the Pine County Attorney. I've been a member of the National Animal Cruelty Advisory Committee with the Association of Prosecuting Attorneys since 2018. I'm also a co-author of the Animal Cruelty chapter for the Minnesota Judges Criminal Bench Book. Having an Office of Animal Protection in Minnesota will bring consistency to the investigation and prosecution of animal crimes and provide expertise for law enforcement and county attorneys in handling these unique cases. These cases come with many complications that require specialization that isn't found in a typical prosecutor's office, especially in rural Minnesota. If the OAP is passed, Minnesota will join other states who have similar offices that have demonstrated successes with those offices. So I urge support of Senate File 1163. I also urge you to support adding the felony animal cruelty to the definition of a crime of violence. Decades of research has conclusively shown a link between cruelty against animals and cruelty against humans. The FBI has found that animal abuse and human-to-human violence are highly correlated and began collecting statistics on acts of animal cruelty in 2016. According to one study, 100% of sexual homicide offenders had a history of cruelty towards animals. 40% of animal abusers have committed violent crimes against people. 25% of those incarcerated for violent crimes have reported substantial cruelty towards animals. 75% of abused women who have companion animals report a history of their companion animal being threatened or harmed by their intimate partner. In 90% of those cases, children were present and witnessed the violence against the animal. And I don't need studies to tell me this either. I've seen these happen in cases as a prosecutor. Section 624.712, subdivision 5 details what is considered a crime of violence. These crimes include felony convictions for murder, assault, domestic assault, robbery, criminal sexual conduct, malicious punishment of a child, neglect of a child, theft of a firearm, harassment, and terroristic threats. And these are the type of crimes that are highly correlated to animal abuse. A person who is convicted of a crime of violence cannot possess a firearm under 624.713 unless such a right is restored by a court. If a person is convicted of a crime of violence and subsequently possesses a firearm, there is a mandatory minimum prison sentence that goes with that. The point of that statute is to keep firearms away from violent felons, to protect public safety and to protect victims. The proposed statutory change within Section 7 of Senate File 1163 would apply only to felony convictions of animal cruelty. Most animal cruelty crimes are misdemeanors. The felony violations are for particularly cruel and egregious abuse. This includes instances where a person intentionally and unjustifiably tortures, cruelly beats, neglects, injures, maims, or mutilates a pet or companion animal to the point of causing death or great bodily harm. This includes engaging in cockfighting, dogfighting, or intentionally and unjustifiably killing or causing great bodily harm to a service animal. Thank you for your attention.
Thank you, County Attorney Fredrickson. Appreciate your being here today.
Thank you.
Good afternoon,
ahead.
Chair Latz and
Officer Forsman.
yes, members of the committee. Nice to see you again. My name is Danielle Forsman, and I serve as a licensed police officer in the city of Coon Rapids. I specialize in animal cruelty investigations. Coon Rapids is a town of roughly 65,000 people. As the sole investigator for animal cruelty for Coon Rapids, I have seized hundreds of cats, rescued dozens of dogs, and even a couple snakes. All these cases took months of evidence collection, taking statements, and working with multiple different agencies. I have investigated hundreds of cases involving organized retail crime, harassment, drugs, and stolen vehicles. And none of those cases were as complex, time-consuming, and emotionally taxing as the animal cruelty cases. For example, I was tasked with investigating a mysterious package one of my citizens had ordered from Thailand. In the package contained rooster dolls, hormones, and vitamins for raising roosters. Through lots of research, including talking to the United States Border Patrol, the USDA, the FBI, veterinarians, local humane agents, and others, I learned about cockfighting and was able to track a cockfighting ring that started in my city and spanned to Wisconsin and California. While working with these agencies, we also uncovered domestic violence, child pornography, and dogfighting. While investigating crimes of animal cruelty, I have been witness to the extent the harm this cruelty has caused. The animals are not the only ones who suffer. The children who are forced to watch their parents abuse or kill their pets, the neighbors attacked by animals who have been hoarded next door, and then the woman terrified to leave her apartment for fear her roommate will kill her service animal. I know you understand the link between animal cruelty and other violent crimes because the legislature has passed laws relating to this link. A conviction of animal cruelty, for instance, is an enhancing factor for domestic violence arrests and is used for determining if the court will grant an extreme risk protection order. This is a good statutory tool for law enforcement, like me, to have, but these tools are useless unless we also have the training and resources needed to understand how to use them and when and why. Police are stretched thin, and the Office of Animal Protection will provide us the education and assistance we desperately need. I am confident through my experience, the Office of Animal Protection would result in more animals being saved, more arrests, and more convictions. And because we know so much about the link between animal cruelty and violent crimes, I believe we will end up saving people's lives by intercepting these criminals early through animal cruelty investigations. Thank you.
Thank you, Officer Forsman. Any questions from the committee for these testifiers? Senator Westland.
Thank you, Mr. Chair. Thank you, Senator Marty, for bringing this. I think we had this discussion, I believe it was last year, that all the years are running together at this point. And thank you so much for sharing the statistics. I know people maybe do not fully comprehend or understand the place that animal cruelty, the part that plays on the spectrum of intimate partner violence. It is a predictor of violence against human beings. It is a crime of violence, and I appreciate the clarification that it would be a felony conviction that would trigger a person from being prohibited from obtaining or having a firearm in their possession. I fully support this. This is serious, and I hope that this committee will support this provision.
Any other questions or discussion before we lay the bill over? Senator Carlson.
Thank you, Mr. Chair. And I guess this is a question for any of you. Probably the officer would know the most about it, but we've struggled with puppy mills across the state, and we have passed different kinds of restrictions there. And I'm wondering if that industry is still thriving. Do we still find that?
Yes, I'm finding.
Officer Forsman.
Sorry. I am finding in-home breeders on the regular. I have seized 80 cats from a garage because people are breeding within their homes. We have Pomeranians that were bred inhumanely, resulting in 30 dead puppies in a backyard. I am running into these cases yearly, if not monthly sometimes.
Seeing no further discussion, Senate File 1163 is laid over.
Thank you,
Thank you,
Mr.
Senator
Chair
Murphy.
and members of the committee. Hope your day doesn't go too long. I know you got so many bills.
Thanks for contributing to our brevity, Senator Marty. All right, Senator Putnam. Senate File 1894. And if your testifiers want to come forward as well, please take seats next to Senator Putnam. Senator Putnam, this is your. It's not your first stop, but we do have an amendment in there. So what we'll do is we'll have you introduce the bill. Looks like the amendment, I don't know, maybe it's technical, I'm not entirely clear, but go ahead and tell us briefly what the bill involves, and then we'll go from your testifiers. And we'll try to focus on this Judiciary Committee's jurisdiction on the bill only, please.
Thank you very much, Mr. Chair, for hearing the bill, and thank you, members, for your attention and your concern. As Senator Lance alluded to, the section of this bill that is relevant or germane to this jurisdiction itself is just one sentence long. It may be helpful, perhaps, Mr. Chair, if you'd like me to give some larger context of the issue, I'm willing to, but if you'd prefer that I stick exclusively to that one sentence, I will do that as well. Do you have a preference?
If you can give us 2 sentences on the larger context, and then 1 sentence on the bill, or as much as you need on the 1 sentence that's before us.
Thank you, Mr. Chair. This bill deals with the phenomenon known as claim sharks. These are individuals who take portions of veterans' benefits in service of getting those benefits increased. There's a nationwide movement right now to provide greater accountability to this activity. 20 states are currently considering legislation very similar to the ones that we have before us. 3 states have already passed legislation like this. One, the New Jersey legislature, passed this bill unanimously through its bipartisan legislature. But it's incredibly important work where we try to find ways to provide accountability and oversight to a practice that is exploiting our veterans. That's the context of the bill. I know that was more than 2 sentences, Senator Latz. I apologize for that. What we're doing now is talking about the teeth that need to be put into this accountability. And now those teeth appear on line 3.18 to 3.2 in the last version of the bill that I have before me. It simply reads, a violation of this section is an unlawful practice under section 325F.69. The subsequent sentence, a person who violates the section is subject to these remedies, is something that we're hoping to remove in an amendment for the sake of clarity, but only for clarity. Mr. Chair, what this does is it puts oversight and sort of activity around this activity within the consumer protection statute. So under current law, only the Attorney General can bring action. The only remedy available to the Attorney General is a civil penalty of up to $1,000 per violation, and civil penalties collected by the Attorney General go to support our troops account. This change in the language, by moving it to this different statute, it will bring these violations within the consumer fraud statutes. And with this change, a violation can be enforced in several ways. First, the Attorney General can bring an action under Section 8.31 for injunction to stop the violation or activity and for civil penalties. Also, a county attorney could pursue an injunction under Section 325F.7, and an individual veteran could sue for damages under Section 8.31, but would need to prove that that action benefits the public. Any civil penalty collected by the Attorney General still goes to the Support Our Troops account. Mr. Chair, that's the essence of the 1-sentence change that we're attempting to make.
Thank you, Senator Putnam. We'll have your testifiers at this time. Whoever wants to start, go ahead and identify yourself.
Greetings, Chair and members. My name is Dr. Christy Janigo, and I'm a 3rd-generation Army veteran. I'm the legislative chair for both the American Legion Department of Minnesota and the Minnesota Association of County Veteran Service Officers. As you may know, the Commander's Task Force, comprised of 8 congressionally chartered veteran service organizations, has unanimously chosen this anti-fraud bill, SF 1894, as one of their 5 key legislative priorities this year. This bill modifies the Veteran Benefits Disclosure Statute and makes it possible for veterans to recoup damages through legal means if they're taken advantage of by bad actors who made promises they didn't keep. We're asking for more effective penalties, which will hopefully lead to greater accountability for those charging veterans for representation and more protection for veterans. Examples of shady tactics unaccredited parties have done include gaining access to veterans' VA login and password, gaining access to their direct deposit information, promising a certain disability rating, stating they can speed up a claim, sending veterans to a private physician for a medical opinion while advising them not to see a VA provider, and even submitting an intent to file to establish an effective date while holding back the claim itself until as close to the year deadline as possible to maximize the back pay the agent will take the cut from. For my day job, I'm an assistant county veteran service officer where I help some of the state's most vulnerable veterans find housing, navigate their involvement with the justice system, and access life-changing veteran benefits. To be good at this job, you have to have a keen interest in people and their stories. Veterans' stories are sacred to me. I retell them to the federal government in the form of a lot of paperwork in pursuit of life-changing benefits for veterans who are down on their luck in every way conceivable. CVSOs walk with a veteran on the journey of their claim. We will also help veterans in need apply for emergency funding through the Minnesota Department of Veterans Affairs or Veterans Service Organization programs. I do not just file a claim and walk away. I surround the veteran with supports for as long as they need it or until I have exhausted all the available possibilities. Chair and members, I love this work. Those of us who do this work at no cost to the veteran are not motivated by profits. It is a calling for many of us. Just this weekend, I did a Google search about veteran benefits, and when I scrolled Facebook afterward, I saw 8 advertisements from parties seeking to charge me for assistance with my benefits, asking me if my rating was too low. And so there's no surprise that in this work, I've had to debunk misinformation claim sharks have perpetuated about the speed of the claims, with veterans believing a for-profit attorney or private business could get them through it faster into a 100% rating. That is unequivocally false. No matter who represents a veteran on federal benefits matters, it is not possible to speed up the VA or guarantee a 100% combined rating. Thank you for hearing this bill.
Thank you, Ms. Janigo, Dr. Janigo?
Thank you.
Did I get that right?
Yes.
All right. Mr. Baker, if you would provide your testimony, but also if you could just supplement anything additional to what Dr. Janigo has said. Appreciate it.
Yes, thank you, Mr. Chair. My name is John Baker. I'm the Executive Director of the Minnesota Association of County Veteran Service Officers. I'm a lawyer and a retired United States Marine. And I will be brief. As a lawyer, I'll use some smart brevity here. Since I became the Executive Director, we started trying to enforce the current law, which is the disclosure law, and working with the Attorney General's office. And one of the first things the AG's office, their Consumer Fraud Division, said, you know, we have a statute that we can prosecute consumer fraud under. And that's one of the reasons we moved this, the current language in the current bill, which had a $1,000 penalty, to the consumer protection statute, which gives more leeway to the Attorney General's office, and it gives a private cause of action to an individual aggrieved veteran. To supplement this as well, Mr. Chair, if I can, this bill in no way limits a veteran's choice. We have over 165 CVSOs in the state of Minnesota. They have a ton of choices. There are currently in the system almost 500 cases that are being represented, 500 veterans in Minnesota, and cases that are being represented by private attorneys. You don't need to represent a veteran for an appeals case. You don't need to be a licensed attorney in Minnesota. A veteran can reach across state lines and hire any attorney that they need. And I will note that one final note for you, Mr. Chair and members. Just about all the information that was received in the packet from these claim sharks, as we call them, all these for-profit companies, not a single one of them is registered to do business as a foreign corporation in the state of Minnesota. So they're violating the law with that to begin with. That's not the talking about the private attorneys that are here in Minnesota that are representing veterans. These are the claim sharks that have submitted letters in opposition to this. Thank you for your time, Mr. Chair.
Thank you, Mr. Baker. Any questions or discussion from members of the committee? The intention, by the way, is to move this on to the Agriculture Committee for the Veterans Subcommittee.
Mr. Chair.
Senator Anderson.
There's a gentleman that would like to testify on behalf of the bill. He's from out of state. So if he could have a brief, short opportunity to testify on the bill.
Yes, of course. Is that John Blomstrom?
That's correct, sir.
Thank you, Mr. Blomstrom. Oh, you're present here in person?
Yes, sir.
Please come on forward, and we'll ask the other testifiers to open up the seats there.
See you again.
All right. Sir, welcome to the Judiciary Committee. Go ahead and identify yourself and your affiliation and give us your testimony. Please try to keep it limited to 1 or 2 minutes.
Yes, Mr. Chair, thank you. John Blomstrom for the record. I am a United States Marine Corps veteran and manager for government affairs with Veterans Guardian. What I do want to say, starting off, is to thank you for the opportunity today, but also to thank my fellow veterans, both on the committee and in the room, for their service to this great country of ours. I just want to say thank you very much to Senator Putnam for bringing forward legislation that would help regulate an industry that needs it. SF 1894, as amended in the first engrossment, is a bill that we can absolutely get behind. This legislation strikes the right balance, protects veterans from bad actors and misleading claims, while respecting their fundamental right to choose how they pursue benefits. The requirement for transparent written fee agreements and the prohibition of guaranteeing specific outcomes are meaningful consumer protections for veterans and their families that we fully support. Importantly, the bill does not impose federal accreditation requirements, ensuring that veterans are not limited in who they can turn to for help. This preserves access and respects the dignity and independence of those who have served. We applaud the committee for advancing the bill that puts veterans first, protects their choices, strengthens consumer trust in this space. Just want to add that we fully support the consumer protection measures that are here. I do want to say that, and for the record, that we would be more than happy to register our business with the Secretary of State, submit background checks for consumer protection from our employees, and work with the state to ensure that we are fully compliant. Thank you, Mr. Chair.
Thank you, Mr. Blomstrom. If I'm not familiar with the Secretary of State's requirements in this space, but if you're doing business here and you need to be registered, please do so promptly.
Thank you,
We
Mr. Chair.
appreciate you coming forward to testify today. Any questions from members of the committee for Mr. Blomstrom? Not seeing any. Thank you.
Thank you, Mr. Chair.
All right. Any further discussion from members of the committee? I am not seeing any. Senator Anderson, would you like to move the bill? I don't think we've adopted the amendment yet. Let's do that. Senator Anderson moves adoption of the A11 amendment.
So moved.
All in favor, say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Anderson moves that Senate File 1894 as amended be recommended to pass and be re-referred to the Senate Committee on Agriculture, Veterans, Broadband, and Rural Development. All those in favor say aye.
Aye.
Opposed? Motion prevails. All right. Thank you, Senator Putnam. Senator Maye Quade. Senator Maye Quade, welcome to the Judiciary Committee. You have 3 bills before us today. Can you tell us which one you would prefer to take first?
Thank you, Mr. Chair, and happy Judiciary Marathon Day to all those who celebrate. Can we start with 1682?
How are you, what treats are you bringing to the committee that's celebrating this Marathon Day, Senator Maye Quade?
I brought my jovial spirit, Mr. Chair.
All right, that's always welcome. Which one did you want to take first?
1682.
Senate File 1682 is before the committee. Members, the packet's being distributed to you. We have very narrow jurisdiction on this because there's one transfer of language from a chapter to another, it appears. So let's really tighten our concentration down and testimony on that provision before us. Senator Maye Quade, if you could give us 1 or 2 lines on the purpose of the bill and tell us what it is that we are here for, and then we'll hear from your testifier.
Thank you, Mr. Chair, members. So right now, there are families who are very engaged with their child's health care, their well-being, and those children are on waits for residential treatment or applied for CADI waivers, but they cannot be released from the hospital where they are at to that treatment because of the wait list. And we want to clarify in law that those families are not neglecting their children by not being able to take them from the hospital to that treatment simply because there is a wait list.
Thank you. Ms. Abderholden.
Thank you, Mr. Chairman. Members, Sue Abderholden, Executive Director of NAMI, Minnesota. When the bill was first introduced, we had this language in 260C, which is the child protection language, and that's kind of like when you're already through the door. And so we moved it to 260E, which is actually the reporting section, so we are at the front door.
All right. Anyone else in the room want to testify on this? Any discussion from members of the committee? All right, members, HHS would like to have this bill back. So Senator Oumou Verbeten moves that Senate File 1682 be recommended to pass and be referred to the Senate Committee on Health and Human Services. All those in favor say aye. Aye. Opposed? Motion prevails.
Thank you so much. Thank you.
Senator Maye Quade, which bill would you like to have next?
Mr. Chair, let's do 1786.
Senate File 1786 is before the committee on foster care licensing. Members, your packet will be distributed to you. Okay. This is coming to us from somewhere else. Okay, members, the intent is to return this bill to HHS. There is an A3 amendment, but this is not the first committee, so, but we do have narrow jurisdiction. It's a new category of people required to have a DHS background search. Senator Maye Quade, give us a couple of lines on the context of your bill.
Thank you, Mr. Chair, members. This bill comes to you with support from the Relative Kinship Licensing Support Network. There was a group that was formed to review federal flexibility that is new for states to establish specific licensing standards for relative kin foster caregivers, which is the preference that we would all want. Someone who knows the child, was related to the child, has been in the child's life, should they need to enter into foster care. This is where 60% of children are placed in Minnesota. But unlike a traditional foster parent or family, these families receive the child first and then begin the process to become licensed foster parents instead of starting at the beginning and then receiving children. And so there has been a lot of work between the department, counties, and this work group to get this bill to where it's at. Did you say 3 or 4 amendment, Mr. Chair?
Ms. Woolman, welcome to the Judiciary.
Oh, Mr. Chair, did you say the A3 or A4 amendment? Excuse me.
Oh, I'm sorry. Let's deal with the amendment. I believe we have an A3 amendment. Yes, that's been distributed with the packet.
And so, Mr. Chair, the A3 amendment clarifies the definition of an individual who is related to the child, provides language that was asked for by the counties on giving information about private agencies, deletes some language, adds some clarifying language on documentation, deletes section 14 and inserts licensed family foster setting disqualifications, requires home studies and background studies to be available in common languages, and then deletes section 18.
Senator Maye Quade, how much of the A3 amendment falls within the Judiciary Committee's jurisdiction? Do you know?
Mr. Chair, I believe some of it does, and I believe it is specific to background studies. I would look to staff. I will say, knowing your preference for amending bills related to your committee and your committee, I did prepare a separate amendment that deals only with what is in the Judiciary Committee's jurisdiction.
Is the rest of the amendment within HHS's jurisdiction? Senator Maye Quade, do you know? Or staff? Ms. Primo?
Mr. Chair and members, yes, the rest of the amendment is within HHS's jurisdiction.
Then I would prefer to take up only those provisions related to our jurisdiction for this committee to take action on. Is there a separate amendment prepared with that?
Mr. Chair, yes, I can have that be passed out.
Let's have that passed out.
Mr. Chair, that would be the A4, and I can speak to that.
Senator Maye Quade says that's the A4 amendment. Is that? I think we are going to have copies made. While that's happening, please speak to that, Senator Maye Quade.
And so the A4 amendment, Mr. Chair, is slightly more narrowed, still clarifies the definition of relative, deletes sections 12 and 14, and inserts in section 14 licensed family foster setting disqualifications, requires home studies and background studies to be available in common languages, and then deletes section 18. And those are specific to the Judiciary Committee.
And why the proposed deletions, Senator Maye Quade?
Say it one more time, Mr. Chair.
Why the proposed section deletions?
It's just, I think it's just renumbering.
Yeah, thank you. Mr. Chair, I think it's just renumbering, because when we delete, for example, section 14, we're inserting different disqualifications. And I believe section 12 and 14 were related to that. Section 14, yes. So it's mostly renumbering and clarifying.
Senator Maye Quade, could you please walk us through in a little more detail what you're seeking to do here?
Yes.
Thank you.
So, thank you, Mr. Chair. So maybe I'll start with the bill overall. The bill overall is meant to clarify and make modern, I suppose, the foster care licensure process for kin and related individuals. Specific to this amendment, in the HHS committee, we have worked with counties, we've worked with DHS, and we've worked with our working group. And there was some work done between HHS and here to make sure everybody is really comfortable with how we're defining an individual who is related. So the first part that you will see in the A4 amendment is talking about the definition of relative, and we're including a person who has was known to the child or the child's parent before the child was placed in foster care. That's the first part of the amendment. Probably the biggest part that the Judiciary Committee has to go to is that right now, and these are flexible federal guidelines that were released that we're trying to comply with or be modernized with. There are a list of barrier crimes in Minnesota law that prohibit you from even being looked at to be approved for foster care licensure. And I'll give you an example. One of them is a specific kind of like a bar fight. Like if a grandpa was in a bar fight when he was young, now he's in his 50s or 60s, that would be a barrier crime to even being looked at as an appropriate setting for that child. And so you have a huge section on what are disqualifying crimes from being looked at. And then there's time barred crimes. So some are 5 years, some are 7 years. And so a large part of the amendment is updating the disqualifications and then updating the if fewer than 7 years have passed and if fewer than 5 years have passed. So in that, you'll see assault in the first degree removed from disqualifications. Disqualifies an individual if less than 7 years have passed since the termination of parental rights. Disqualifies an individual if less than 5 years have passed since assault in the first degree. And inserts language stating that disqualifications begin from the date of the alleged violation instead of the conviction date or, because it takes a long time sometimes for a court to happen. Then the next section in the amendment requires home studies and background studies to be available in common languages. And then in section 18, which I'm going to turn to, it's deleting the appropriation for fingerprinting devices. That is what the amendment does, Mr. Chair.
Senator Maye Quade, thank you for that. In any of these changes, are they lifetime bans or disqualifications?
Yes. Yes, Mr. Chair, I believe first-degree assault was added in the, was removed from the disqualifications, and Ms. Woolman can speak to that more fully.
What do you mean removed from the disqualifications? I see it added to a list on page 3.
On the 5-year list, but it's
Yes.
removed from the permanent list.
Yes, Mr. Chair, there's 3 different sections. So there's a permanent disqualification, there's a 7-year disqualification, and then there's a 5-year disqualification. We've removed first-degree assault from the permanent disqualification, and I believe we've moved it to the 5-year disqualification.
All right. Let's hear from your testifier. Ms. Woolman?
Nice to see you.
Nice to
Chair
see you.
Latz
Welcome to
and
the
the rest of the committee. My name is Joanna Woolman. I'm a professor at Mitchell-Hamlin School of Law. I'm also the executive director of a nonprofit, and I'm a 25-year attorney representing parents and relatives in child protection cases. I can briefly walk through, I think, the 3 relevant provisions for this committee today. We are making 3 proposed changes to the background studies for relatives and kin in Minnesota. The first change, which is contained in section 12, is to remove, as Senator Maye Quade just said, the crime of first-degree assault from the list of permanent licensing barriers and moving it to the 5-year disqualification period. Briefly, from a federal law perspective, the Adam Walsh Act is the governing statute that determines what states have to make permanent bars to receive federal funding around licensing. And the Adam Walsh Act requires certain things to be barred permanently, including a felony conviction for child abuse, a crime against a children, rape, homicide, sexual assault against a child. But this list does not include first-degree physical assault. The Adam Walsh Act does not recommend making first-degree assault a permanent bar. Minnesota's statute, however, does make first-degree assault a permanent bar. We did a survey of about 65 licensors in Minnesota, both community and county, and they identified first-degree assault as the most problematic barrier for relatives seeking a license of all the crimes on the permanent barrier list. So this comes up, as Senator Maye Quade said, often, unfortunately for men who have had a first-degree assault charge early in their life, because often these crimes are committed by younger people, and then are in their 50s or 60s and seeking to be a foster care parent for their grandchild or niece or nephew. And because first-degree assault is a permanent bar, there's no workaround. There's nothing we can do. It is just a hard no, full stop. So by moving this crime to the 5-year list, we are certainly not saying that it is insignificant or might not be a reason to deny a license. We are simply giving an individual the opportunity to apply for a foster care license and be considered. And I would ask the committee to take that step today. The goal of these changes is to expedite the process to license relatives and to make it easier by removing barriers without compromising child safety. And there are still many mechanisms in the law to evaluate the safety of a child other than whether or not someone has this conviction at some point in time. That's the first change we're recommending. From a national perspective, 34 states go beyond just those 7 defined Adam Walsh Act crimes. And Minnesota is definitely in we add a lot more than the Adam Walsh Act on both our permanent bar and our 5-year bar. So we are significantly away from what the federal statute recommends, or federal in this particular arena. The second thing we're looking to change is the statutory bar relating to a prior termination of parental rights. So right now in Minnesota, if you have either an involuntary or a voluntary termination of parental rights, you are barred from applying for or seeking a foster care license for a period of 20 years. I think it's important to remember that there are many journeys to having your parental rights terminated. Sometimes it's after a long-fought trial, and if you lose that trial in Minnesota, you have an involuntary termination of parental rights. Sometimes this happens, often in the cases of dads, if you don't get notice and don't show up for court. So if you are not at the address that you said you were, or you don't receive information, your parental rights could be involuntarily terminated simply for not coming to court. There are very serious cases that result in a termination of parental rights, and there are cases that involve perhaps more rehabilitative type situations. For example, people struggling with mental health or chemical dependency issues. In the case of a relative foster care situation, our communities of color experience significantly higher rates of termination of parental rights across the board. And so this 20-year bar may be too broad in that it is disqualifying individuals for too long a period of time. Now, if an individual has had a termination of parental rights, that is critically relevant information to licensing someone. But that information should be considered amongst all of the other safety concerns. And that 20-year bar, again, creates a very severe barrier to even the possibility to consider someone for this role. And I would say that the federal government, through the Child Abuse and Prevention Treatment Act, does not require any state to statutorily bar somebody because of a prior termination. It does require consideration of the child abuse registry in the state, and every single state, of course, considers this information. Minnesota has a way through non-disqualifying information to look at our child abuse registry, which an individual is placed on if they have child protection history or a termination of parental rights. Minnesota and Kentucky are the only states in the country that codify this barrier in their statute. Every other state considers it, but doesn't automatically disqualify someone statutorily as we do. So we are seeking to move this 20-year bar to a 7-year bar. And the compromise here was negotiated between many stakeholders, and I think speaks to Minnesota's seeking a balance between safety and opportunity. The third provision today is to move the start date on that 5-year bar category of crimes from the date of the incident or the alleged incident versus the date of conviction. So right now in Minnesota, we start that 5-year barrier period when a conviction occurs. The national model standards for kin really recommend that states think about starting that from the date the crime or incident happened, because sometimes there can be a really long delay between the incident and a conviction, and then that 5-year bar suddenly turns into a 7-year bar or an 8-year bar. And so in order to live up to the real spirit of the Adam Walsh Act, we're asking that to start at the date of incident. Again, states are mixed on this, but more states are moving towards a 5-year bar for the date of the crime or incident in the category of relative licensing. And we're asking today that Minnesota join that group of states and allow relatives to be considered from the incident versus conviction date. Thank you.
Thank you, Professor. I do have a question for you. What is the starting date for the 7-year bars or the other bars?
The 7-year bar does not currently exist. We are asking that 20-year TPR to be moved to 7 years. So that would be the only category under the 7-year period. And then the permanent bars, sadly, you're just done.
So the one you're moving to 7 years, would that also start from the date of the incident or date of conviction?
That would start from the date of the order of termination of parental rights.
And you believe that's the appropriate place to start that?
I do.
Senator Maye Quade?
Yes, Mr. Chair, I think yes, because if there is an incident that resulted in an investigation that could lead to the termination of parental rights, but doesn't, I mean, you'd want it to start when the decision was made.
All right, so members, we have before us now the A4 amendment that we've been discussing. Is there anyone else wish to testify in connection with this proposed amendment? Not seeing anyone come forward. Any committee discussion on it? I'm not seeing any. Senator Oumou Verbeten moves adoption of the A4 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Is there any further element of this bill that will be coming before this committee for consideration? Or did we cover all of it in the A4 amendment? Ms. Primo.
Mr. Chair and members, I believe there's an oral amendment that would delete section 13 of the underlying bill, the piece that modifies consent provisions. I believe HHS counsel may have consulted with the author on this one and potentially the advocates. And the issue is that I believe what the language on lines 11.5 to 11.11 is doing may not be in alignment with what was intended. I believe the intent was that DHS would use one form for purposes of getting the required consent, and that it would be an administrative issue as opposed to what maybe the language does, which is prohibits the commissioner from getting the required consent at all.
Senator Maye Quade or Professor Woolman?
Yes, Professor Woolman has some comments.
Professor Woolman.
Thanks. I have not talked to DCYF about this, but I do understand their concern, and I did talk to the reviser. I think there will be several additional changes that may happen to this bill ahead of HHS. The way that this language is currently drafted is confusing, and we need to clarify the process that we're contemplating, which is basically the way that the state operates right now is that if you have to do an out-of-state background check, you have to ask an individual each time you do a separate state. So it's like, say someone lived in 4 states. You have to be like, hey, Mrs. So-and-so, can you sign this form for this state, this form for this state? That's onerous, and we're trying to streamline the process for relatives. So we need to change the language here to reflect that an individual can let the licensor know, whether that is a state or community licensor, or I'm sorry, a county or community licensor. And then the state would be able to attest to all of the other states they're seeking, like Mrs. So-and-so said it was fine if we contact multiple states with this one signature that she has given us. So we need to make the language match with our intent to streamline the process, and we are eager to do that early next week before we head back to HHS.
Ms. Primo, would that be a matter for consideration by HHS, or do we need to deal with that here?
Mr. Chair and members, that specific issue that's outlined is definitely a DHS issue. I think it would make sense in light of that to delete Section 13, because what Section 13 does is a judiciary issue. It prohibits the collection of that consent.
That makes sense.
Senator Maye Quade, are you okay with that? And then you can deal with any new language in DHS?
Yes, Mr. Chair.
Professor Woolman, you agree?
Sounds great, yeah.
Any discussion from members of the committee? Senator Oumou Verbeten moves deletion of Section 13 of the bill as amended. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Any further discussion or action? Senator Maye Quade, do you want? Oh, Senator Limmer, I'm sorry. Did you have a comment? Senator Limmer.
Thank you, Mr. Chair. Just a quick definition I need. Page 1, line 16. What does important friend mean? Is that a term of art, or is there a legal definition to it?
Senator Maye Quade.
Thank you, Mr. Chair, and thank you, Senator Lemmer, for the question. I was excited to use this example in the HHS committee, and I'll use it here as well. I have godparents. One is passed, but I still have a godmother who is alive. They're not related to me or my brother by blood in any way, shape, or form, but they lived like less than a mile from us their whole lives. And in our younger years, certainly, if anything had happened to my parents, they would have assumed guardianship over us. But if we had to be taken out and placed in foster care, they probably would have been the most appropriate people for us to be placed with, and so they would have been considered important friends, even though through marriage or blood they have no relation to my brother or I.
Mr. Chair?
Senator Limmer.
Well, what else could the term important friend, how would it be defined? You've used the example of a godparent, but that certainly is not in state statute, so how else could it be defined?
Senator Maye Quade.
Thank you, Mr. Chair, and Senator Limmer. I mean, yes, I used godparent as the example for my family, but there's lots of different types of families, different cultures, different places in Minnesota where the importance, we don't want to put words around what is important because the importance is the piece, if that makes sense. I think the plain reading of important would be important there. But the licensors and the state, they're the ones who are determining through the parents from removal, from the children themselves, from the lives around them, of the relevance or importance of those people to that child or those children.
Mr. Chair,
Senator Limmer.
after hearing your answer, I can't help but disagree. I think when there's a term in statute, we should surround that unknown word with words that define it. We do that often in legislation, and I'm just wondering how a judge would define the term important friend if there was a contest in a courtroom. So I would hope that
before this gets to the floor, that we would find some definition to that.
Any further discussion? Senator Croon.
Thank you, Mr. Chair. Just to piggyback off that, I mean, it's not, I can somewhat understand important friend of the child's parent or custodian, but it says important friend of the child, which I don't know how that's workable in a court setting. If the child said, "This is my friend," is that the judge just supposed to treat that person as an important friend? You know, and maybe someone can say if this term is used anywhere else in statute, but I'd feel more comfortable if we used a term that has a definition around it, or even better if it's used somewhere else in statute. At a minimum, I think "of the child" needs to be stricken there.
Senator Maye Quade.
Thank you, Mr. Chair, and Senator Croon. If you look at 1.17, you know, it includes an individual with whom the child has resided or had significant contact or has significant relationship to the child or the child's parent or custodian. A great example might be, and this has happened to friends of mine, a friend of mine, where she was removed from her family and placed with her best friend's family because she was often at that best friend's family's house, in part because of what was happening in her own home. And the parents were close to her, and yeah, that was an important relationship of the child and not necessarily the parents.
Senator Croon.
Thank you, Mr. Chair. And then maybe it should just say an individual who is related includes, and then go right down to that, an individual with whom the child has resided or had a significant contact or has had a significant relationship to the child. I mean, I don't know. That's just one thing. Including doesn't define important friend, because it doesn't limit it to other situations. So if we're talking about people that the child has resided with in the past, that's something that's at least objective for a judge to make a decision on. Whereas just important friend, I don't know if I'm a judge what I do with that term. Like, how do I make a determination? I mean, like I said, if it's the parent's friend, then you have testimony supposedly, but a child's friend, I don't know, that just seems odd to me.
I think it's a little bit hard for us as a legislature to be too prescriptive as it might play out in individual cases, and maybe unnecessarily tying a judge's hands and making the right decision here. But Ms. Primo has a suggestion maybe for consideration here. Ms. Primo?
Mr. Chair and members, the amendment would be page 1, line 16, delete the comma, insert a period, and insert a period. Nope, let's start that over again. Page 1, line 16, delete the comma, including, insert period, an important friend means.
So Ms. Primo, it would read at the end of custodian, it's the end of that sentence, and then it defines an important friend. An important friend means an individual with whom, et cetera. Is that correct?
Mr. Chair, yes, and it's possible this needs some technical edits, which can hopefully be taken care of in HHS and after review by HHS counsel, like maybe moving it to its own separate subdivision.
Senator McQuaid.
Thank you, Mr. Chair. Yes, to what Ms. Primo was saying, and I think we could change important friend to an important individual. And then I think then after the period and delete including, it could be an important individual means a person whom, and then on from there. And I just want to name too that I understand Senator Kroon and Senator Liber. I understand what you're talking about with the language, like an important friend of the child an adult could feel weird, and I understand what you're saying. So if an important individual might feel more appropriate, I get that.
Senator Kroon?
Thank you, Mr. Chair. I think that Ms. Primo's suggested amendment makes it better. I mean, and then it kind of goes to what is a significant relationship, but I guess that's something I think a judge would have a better time adjudicating than close friends. So I think the amendment is an improvement, and I would make that motion.
Senator Maye Quade, as to the proposed amendment.
Yes, with the things we've bandied about orally, yes, I'm fine with that.
All right, so Senator Kroon moves to amend line 1.16 by deleting the word friend and replacing it with the word individual, deleting period, including, in its place inserting and capitalized an important individual. Oh, individual's already there. And important. So an important individual means an individual with whom, is how it would read. Correct, Senator Kroon?
I think it's delete the comma.
Delete comma.
Instead of the period, but
Correct.
other than that, I think you got it.
You're right. Delete the comma, including. Insert, so it will read, an important individual means an individual with whom the child. Any questions about the proposed amendment? Senator Maye Quade, friendly amendment?
Friendly amendment, Mr. Chair.
All those in favor say aye.
Aye.
Aye. Opposed? Motion prevails. The amendment's adopted. Any further questions or discussion from members of the committee? Senator Westland and then Senator Howe.
Just very quickly, we keep talking about the court here. I don't think the court is doing this. As I understand it, this is licensure by the commissioner, and that they are going to be doing a full investigation of anybody who's going to potentially be caring for the child. And so I just wanted to be clear that this is not that there is a full licensing process that's going on here. Do I have that right?
Senator Maye Quade.
Thank you, Mr. Chair. Yes, Senator Westland, you're right. I actually had leaned over to Professor Woolman and said at court. It is like a licensing agency and the state and a county, so it's a pretty arduous or involved process, I should say.
Senator Howe.
Well, basically, that was my question is, so even a relative is going to have to get licensed and background checked. I can understand the background check. I'm a little, don't understand even for a relative to get licensed, but now I understand what the bill's trying to do.
Mr. Chair.
Senator Westland.
It's a day when we're mind melding, Senator Howe.
Any further discussion on Senate File 1786? Not seeing any further discussion. Senator Oumou Verbeten moves that Senate File 1786 as amended be recommended to pass and be re-referred to the Senate Committee on Health and Human Services. All those in favor say aye. Aye. Opposed? Motion prevails. All right, Senate File 1289, Senator Maye Quade.
Thank you, Mr. Chair and members. Mr. Chair, if it's okay with you, if someone would be willing to move the amendment.
So moved, Mr. Chair.
Senator Oumou Verbeten moves adoption of the A1 Authors Amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment's adopted. Senator Maye Quade, please describe your bill.
Thank you, Mr. Chair and members. This bill is very short, and it was born from a really specific circumstance. Last June, the Hennepin County Attorney announced that she would be dropping charges against 40-some pregnant women who had been charged for using drugs, which is not a crime in the state of Minnesota. And through that, it was revealed that there were clearly a lot of women in this state who were being charged and prosecuted for crimes that aren't crimes. The crime was that they were pregnant. And so this bill would essentially say that a pregnant person cannot be charged or convicted of a crime for conduct that they would otherwise not be criminal. There have been other examples in other states. There was a woman who was, I believe in Iowa, who was charged with a crime for falling down the stairs because she was pregnant. It's not a crime to fall down the stairs. Shouldn't be a crime to fall down the stairs when you're pregnant. There was a woman, I believe in Alabama, who was shot. She was charged with a crime for being shot because she was pregnant. It's not a crime to get shot. It should not be a crime to get shot when you're pregnant. So even though this bill seems, it's short and it seems odd, it really is to make sure that we have in statute clear language that says it is not a crime to be pregnant and then be shot, experience abuse, which is one of the most common ways that pregnant women are charged with crimes, or to use drugs. It's maintaining the standard of criminal conduct for everyone and not having special standards of criminal conduct for pregnant women.
Senator Maye Quade, we ran into a related issue on a bill earlier in the week having to do with proposed immunities for medical providers or healthcare providers. And the question came up as to whether or not it actually would provide immunities for criminal conduct that occurred in certain settings. And I see that you have language here that specifies the immunity for conduct that would not be criminalized if the same person was not pregnant. I'm trying to understand the scope of that, because then you include use of drugs, which would be a crime for someone who is not pregnant. Does this provide them with immunity if someone is pregnant and using drugs, otherwise criminal conduct?
Mr. Chair,
Senator Maye Quade.
I don't believe it is a crime to have used drugs. It is a crime to possess them. It is a crime to sell them, manufacture them, traffic them. But it is not a crime, unless you're pregnant, apparently, to have used drugs. And so, excuse me, and so then this would say that similarly, if you are pregnant, much like when you're not pregnant, it is not a crime to have used drugs.
Except that when you are using drugs and you're not pregnant, you're endangering only yourself. When you're using drugs and you are pregnant, there is, at some scope of description, something else that is being affected by the drugs. How does that fit within this context? I mean, oh, this is hazy and fraught, this whole conversation might be, but I think we need to suss some of this out to evaluate what you're proposing here.
So, Mr. Chair, what you're delving into is certainly an important topic of philosophy, some religion, but in terms of law, the way that we have all other laws when it pertains to conduct that pertains to another person, it has to involve another person. And so this, there isn't a special status of being pregnant that makes something that you do a crime. So I will say that in the amendment, we deleted immunity because nobody's immune from prosecution or conviction for conduct, because there's no crime, or there shouldn't be any crime that is only a crime when you're pregnant. If I was drinking and driving and pregnant, I could absolutely be arrested for drinking and driving, and charged and convicted with that. If I stole an iPhone worth $500 and I was pregnant, that would still be theft. There's no immunity from any crimes that exist. It's just that the crime of being pregnant in and of itself is not a crime, and so there's no behavior, or there should not be behavior that you conduct while you're pregnant that could get you charged with a crime that you could not do when you weren't pregnant. Yes, you understand what I'm saying?
I do. Thank you for that clarification. So there isn't any conduct that would otherwise be criminal that would be covered here?
Correct.
We have a couple members that have questions as well. Senator Howe, and then Senator Limmer.
I wasn't prepared quite to go yet, but I will go, but.
Well, you can waive your.
No.
I'll come back to you if you wish,
I just
Senator Howe.
struggle, Mr. Chair.
Rather your question be well thought
Senator
through.
Maye Quade, my question is if I have to believe that the prosecuting attorney, if they're going to prosecute, would have to determine what the intent was. Because if their intent was solely to do harm to the unborn child, I would still believe that that should be a crime. Now, why they're doing that is not, I guess that's the piece that they have to determine. But if they're drinking to excess, taking drugs, falling down the stairs for the sole purpose of harming the unborn child, whether it's because they're upset with the father or or the condition that's going on, I guess that's where I have a problem with this language. Thank you.
Senator Limmer.
Thank you, Mr. Chair. In listening to this, I was wondering how the state handles fetal alcohol syndrome when the woman who is intentionally drinking despite the fact that she's maybe pregnant. I don't know if that's a criminal act. Perhaps Mr. Backus could help us out with that, or.
We'll ask counsel. Ms. Primo.
Mr. Chair and members, the main statute on that is in our Maltreatment of Minors Act. It's under 260E.31, and where persons are mandated to report. However, if they meet the qualifications for that sort of reporting, it's reported to the local social services agency, and they are one of the things they would do is provide services and offer services to that person related to that substance abuse issue. And then they can also engage with like the civil commitment process if the person refuses to go through with those services.
Mr. Backus has a supplemental comment.
Mr. Chair and members, we do have a host of crimes against unborn children, but in those statutes, the pregnant woman may not be charged with those crimes.
Senator Westland.
Thank you, Mr. Chair, and thank you for that clarification, Ms. Primo. There's a difference between a civil intervention to try to help someone who's experiencing or has a substance use disorder or an alcohol use disorder and trying to intervene and provide help. And basically, that's what this is, that there's a mandated reporting piece to this, but it is not criminalizing the conduct. And I would simply say that I think the criminal element that we're talking about is specifically related to if somebody ingests drugs, but it does not include the idea that a woman may be ingesting alcohol, either of which could potentially be harmful to an unborn child. It makes a lot more sense to try to intervene and provide some support and help for someone experiencing an addiction in their lives than it is to try to criminalize the behavior. And it is absolutely not appropriate to criminalize the behavior simply because the person is pregnant.
So it sounds like under current statute, that could not be done anyway, under the statute Mr. Backus just cited, if I understand it correctly. Senator Maye Quade.
Thank you, Mr. Chair. And yes, you are understanding the statute perfectly clearly. I think the problem is that we had all of these arrests, and that was just one county. And so, that's why this language is really important. We don't want to criminalize people for being pregnant. Because if we follow down that logic of, they fell down the stairs intentionally, then was it they ate soft cheese intentionally? Was it that they ate, spinach that we knew? There was a listeria outbreak. I mean, there's a lot of behavior that you can then criminalize because a person is pregnant. And it's a really dangerous road to go down. And so I want us to be clear in statute that the status of being pregnant and then doing legal things is not criminal, which is something that is happening right now.
In Minnesota, Senator Maye Quade?
In Minnesota and across the country, yes, Mr. Chair. But specifically in Minnesota, the impetus for this was the 40 women in Hennepin County who had their cases dropped after it came to light that they had been charged for using drugs while pregnant.
And how were the cases dropped? Help me understand that.
Thank you, Mr.
Senator
Chair.
Maye
And
Quade.
when we do have, I think, Hennepin County folks in the audience, there was a report released, I think that had somebody looking through the thing, then they found there were 40 cases that had been charged, that were pregnant women who had been charged, that had been charged for using drugs. And so they decided to not continue with conviction or charging. And then I think there are some that they're looking to go back and see if they can expunge or if they can recommend expungement.
So just help me understand this. I want to make sure I get the context right. There were charges, and maybe we got some witnesses here who can explain this, but if there were charges brought that could not have been brought because of Minnesota statute chapter 609.266 or some other provision, how did they proceed beyond even the charging point without being dismissed?
And Mr. Chair, I don't know the answer to that. I tried to read so many news articles to obtain that specific information. There was a 25-page report that was attached to the Hennepin County Attorney's decision, but the specific cases, the specific charges, I'm not clear what they were, but I will say maybe the important piece to add to this is that when asked, the MPD chief said, we're going to keep doing what we're doing, and we're going to keep arresting people for this. And that was why I was like, well, that can't keep happening. And so that was the impetus for this language.
Okay, I think we have a testifier here. Go ahead and identify yourself for the record, please.
Hello, thank you, Chair Latz and the rest of the committee members. I am Jillian Deese, D-E-A-S-E. I'm a managing attorney at the Hennepin County Attorney's Office. To speak to the question presented, this was not my area of expertise, but my understanding is that those cases were being prosecuted under 609-378, which is the child neglect and endangerment statute, which does not specifically define child. So my understanding was because it does define child?
Under 18, yeah.
Okay, so I believe that's what was happening in practice in Hennepin County and recently stopped under County Attorney Moriarty.
Mr. Chair.
Senator Maye Quade.
Thank you, Mr. Chair. The statute does define child. It's persons under 18. Thank you.
I would assume persons is defined somewhere as well. Is person defined in statute as not including or including an unborn child? Do we know?
Mr. Chair,
Senator Maye Quade.
thank you, Mr. Chair. It would not be, it has to be a person who has been born. That's why we're born at, 0 days and not 9 months. But I think we might have a definition of unborn child in statute that differentiates between persons or minor, individual under the age of 18, adult over the age of 18, and so on.
Ms. Deese, you have something to add, it looks like.
Yes, thank you, Chair Latz. It's my understanding that as Senator Westland articulated earlier, these were the results of mandated reporters. So a parent gives birth at the hospital, the child tests positive for substances that presumably came from the mother, which of course then that is a live child who is a person under the age of 18.
But any conduct would have occurred before the child was born,
Yes.
right? Ms. Deese?
That is correct. I believe under 609-378, Chair Latz, it does, I think it was prosecuted under, is there a second subdivision? about deprivation, maybe. Again, this is not my area of expertise, but I believe that was the statute for which the county was prosecuting.
I guess what I'm trying to figure out is, was a crime committed under any interpretation of existing statute? Clearly, their charges were brought, something went forward, whoever presumably was defending the charged individuals, maybe they weren't represented, but maybe someone dropped the ball and didn't get it dismissed for lack of probable cause. I don't know. I agree with the purpose of the bill we have before us. I'm just trying to figure out what's needed, or if we're simply putting additional suspenders around an area that's already got a really solid belt. Maybe not quite so solid a belt, but I mean, if the statute is what it is, I'm not sure that we should be in the habit of adding statutes that say you can't do what other statutes already say you can't do. So I'm trying to figure that out here. Senator Westland?
Thank you, Mr. Chair. The information in our packets includes a report on from Fox 9, and what I understand is that the county attorney's office may not be charging these things, but it does seem to indicate that the Minneapolis Police Department is continuing to recommend charging in these instances. So there seems to be a dispute between the Minneapolis Police Department and the county attorney's office, but if the police department is continuing to intervene and recommend charging, it seems to me that perhaps we do need some clarification to indicate that this is not appropriate. Even if the county attorney chooses not to prosecute, there is still, I'm going to guess, a police report. There's a recommendation that there should be a charge brought and there should be a prosecution brought. That's going to be in that person's record, whether or not there was ever a prosecution or conviction for it. And so it seems to me that this makes sense to be clear to everybody that it's not appropriate to pursue criminal charges or to recommend criminal charges on the part of the police department.
Senator Westland, I'm just struggling a little bit with this because I agree with you, it's not a great idea to criminalize substance addiction. And yet, as a practical matter, we do every day for someone who's in possession of a small amount of a controlled substance because they are addicted to it. It's for personal use only. That was the basis for my initiative a number of years ago for dropping the lowest level possession charge from a felony down to a gross misdemeanor. Didn't eliminate it altogether, but that was the whole point, was that it's really personal use based on addiction at that level, most likely. And nothing more nefarious than that. So I guess I'm still kind of struggling a little bit with adding a statute that says you can't do what already can't be done. Or on the flip side of that, if they're charging abuse or neglect because someone is carrying an unborn child or a fetus and they knowingly continue to do drugs or drink alcohol or otherwise endanger that unborn child, as it's defined in our statute, at some level, is that conduct going to be more than just substance abuse or addiction?
Mr. Chair?
Senator Westland.
My understanding, and perhaps the county attorney's office can clarify, the referrals and recommendations for prosecution were under 609.378, I believe, which is in fact neglect or endangerment of a child. And an unborn child doesn't fall under that statute or that description. And so again, I hear what you're saying. Now, there is as we were discussing earlier, there is a process to report chemical or alcohol use to someone who can actually intervene and provide services to the pregnant person to help them with their addiction, but that is a whole different thing than criminalizing the conduct and trying to charge and prosecute somebody where clearly it does not meet the statutory definition, and yet the referrals are happening. So if the police are reporting something, it should be being reported to something on the civil or through a mental health process or something to obtain intervention. But it sounds to me like that's not what's happening. And so I think we do need to be clear that those sorts of referrals for criminal prosecution shouldn't happen. And so I guess for that reason, I think I understand your conundrum as well, Mr. Chair. But if the practice on the ground is that people are actually being referred for criminal prosecution, then I think that there is a problem that we should try to address.
So thank you for the clarification, Senator Westland, and it does help me because now I've set aside the issue of the unborn child under the 609.378. It would be illegal to proceed. There'd be no charge, a lack of probable cause to charge someone with abuse and neglect unless for use of a substance that resulted in a child being born with controlled substances in their bloodstream, right? So it sounds like there'd be no probable cause, and there's no way these prosecutions should have proceeded, and I don't care what the Minneapolis Police Department says. If there's no probable cause, they should not be proceeding with this. So then my question is, why didn't the prosecuting authorities in the city of Minneapolis decline to prosecute? And why didn't any defense lawyers proceed with a motion to dismiss for lack of probable cause? I mean, both of those safeguards should have been in place even for the unrepresented party. The city attorney should never have proceeded with these charges. So where are the safeguards here? And do we need to pass a statute that says you got to do your job? Senator Maye Quade.
Mr. Chair, I want to say, too, that this is but one county. I don't know what's happening in 86 other counties, too. And so I do think there needs to be something very, very clear because we could have 86 other counties that are doing this and we don't know because those county attorneys haven't dropped charges. So I think to your question, yes, we do.
Ms. Dees.
Chair Latz, thank you. It is my understanding this is happening in other counties besides Hennepin County. I understand where you are coming from as a defense attorney. I do, in reading the statute, think that it would survive probable cause. It's not criminalizing what it is criminalizing is that the parent, while pregnant and ingesting substances, endangered the child by creating the child to be placed in a situation likely to substantially harm the child. We have proof of that when the child is born with these substances because of the mandated report. So I understand where you're coming from, Chair, but I do think that this is a problem not limited to Hennepin County and that it has survived years of prosecution. Maybe faulty, but it has.
Ms. Dees, but it's your opinion that under the language in the statute, it would survive a probable cause challenge?
Chair Latz, it is.
Any other members of the committee? Senator Kroon.
Thank you, Mr. Chair. I think why we're struggling with this bill so much is because I don't think anybody has, I heard pointed to an example of a statute where it's illegal for a pregnant woman to do something that's not illegal for a non-pregnant person to do. And so I don't know what we're even talking about. That's where I'm at. Like, nobody's identified a statute. I mean, we've identified 609.378. I think that's pretty clear. I think you're right. If there's a problem with law enforcement referring cases for prosecution that aren't crimes, do we need to write a statute to correct that? I mean, that's a different issue, and I don't know what's going on between the Minneapolis Police Department and the Hennepin County Attorney's Office, but at a minimum, Mr. Chair, if there is ambiguity in 609.378, the bill should be to revise 609.378. We shouldn't be doing some blanket immunity or whatever it's called now to get at a specific other statute. If there's a definitional problem in 609.378, somebody should draft a bill clarifying the definitions in that particular statute. I don't know what really happened there, but this bill isn't the solution. This just creates all sorts of confusion in trying to put into law a solution for a problem that doesn't exist. I don't know. I just don't think this is good lawmaking at all.
Senator Maye Quade.
Thank you, Mr. Chair. We've really narrowed in on substance use disorder, alcohol use disorder. One of the most common reasons pregnant women are arrested and charged with crimes are for being in abusive relationships, for being abused. It's almost as common as drugs and alcohol. And so, there is this tendency to criminalize behavior that is otherwise that is not illegal because a person is pregnant. And it's real, it's happened. I mean, we have the article here with the 40 women in Hennepin County, but it happens in many other counties and many other circumstances. I mean, if we walk down the road too far, I mean, when I was pregnant in the first 3 months, you're really not supposed to take hot baths because it can damage the development of the nuchal tube, which is actually very important for your brain development. I mean, we can criminalize a lot of totally legal behavior because it impacts your pregnancy and the birth of your child. And that is not, we shouldn't be wandering there with law. And so I think because we just have too many examples of the ways in which that has happened, this is where that bill comes from. Substance use disorder and alcohol use disorder are part of it, but there's lots of different ways we criminalize the lives of pregnant women for living because they're pregnant, and that's what I'm trying to move us away from.
To Senator Kroon's point, do you know if there are any other statutes besides 609.378 that have been used to bring charges?
Mr. Chair, I don't know. We did extensive research to try to learn that, but because we were only able to know about the cases from the Hennepin County Attorney's Office, we were only able to get the ones that they've been using. I haven't been able to find the others.
Senator Westland.
Thank you, Mr. Chair. Senator Maye Quade, so zeroing in on a question here then. So is 609.378 also being used then to charge women who experience abuse and the other things you have listed here? Like, are they just generally saying you're basically exposing a child to neglect or endangerment? So I'm just curious if that is sort of the catch-all statute that's being used for things other than substance use. That might help answer some of the questions.
Senator Maye Quade.
Thank you, Mr. Chair. I'm being advised that this is probably the most likely statute, but without being somebody who's arresting and recommending charges and without being a defense or prosecutor, I wouldn't know.
Senator Westland.
I know.
Mr. Chair. Mr. Chair.
Senator Westland.
I try really hard not to blow people's stuff out of the water without talking to them first, but I do, in speaking with Senator Maye Quade and sort of piggybacking on, I think, what Senator Kroon was saying, we're kind of wondering if actually making the change in 609.378 might not be a better tactic, because if that is sort of the statute that's being used to charge pregnant women for a variety of things under that, there's a catch-all, which is the knowingly causing or permitting the child to be present. So it seems to me like that would be the thing that would be used in the abuse situation, so on. And so I wanted to just briefly speak with Senator Maye Quade to see if that might be the place where where this would actually be better housed, to indicate that that this does not apply to women who are, to pregnant women. This is not fully formed or fully thought out, but it certainly might be something that would more, that this might get to the issue better, I think, and that's what Senator Kroon, I think, was trying to get to.
If that is a direction which Senator Maye Quade or others wish to go, council, without having talked to me first, drafted up some language that might accomplish that.
Okay. Or me.
I swear, without having talked to me first, but picking up on the tenor of the conversation. But let's see what Senator Maye Quade says Senator Kroon has to say about that. Senator Maye Quade.
Thank you, Mr. Chair. And I appreciate both of the suggestions, and I guess I wonder if maybe this bill could make a subdivision 3 under 609.378.
I'm sorry, would you please repeat that? I was talking to council.
It's okay, Mr. Chair. I was just wondering if maybe this exact language could make a subdivision 3 on 609.378.
Well, Mr. Backus has drafted a subdivision 3.
Okay.
But with some different language.
Okay.
Mr. Backus, do you have a recommendation either as to the language you have written or Senator Maye Quade's query as to whether or not the language in Senate File 1289 ought to be adopted in to 609.378?
Mr. Chair, maybe rather than answering that, maybe I could read the language I have, and Senator Maye Quade and others could react to that. But you could always, cobble both provisions together, I suppose. But what I was thinking is, again, a subdivision 3 to 609.378, the head note would be exception. And the substantive language would read, a person may not be charged with or convicted of a violation of this section for acts committed before the birth of a child.
Or an alternative could be to take the bill in front of us and on line 8, after crime, insert under this section. Make that a subdivision 3. So let me ask first, Senator Maye Quade, are you comfortable with the direction of the conversation?
Yes, Mr. Chair.
So then I think the question is, what would be the best language to accomplish this, and whether we wish to conclude that discussion here and now, or whether we may want to give a brief recess to this bill to finalize comfortable language and get other items on our agenda worked through too. I'm just being mindful of the clock as well as the importance of getting this right. Senator Maye Quade.
Mr. Chair, and I always appreciate I bring you fun bills. I wonder
Yes, thank you for that.
You're welcome. I wonder if we could take the language that Mr. Backus suggested, a pregnant person may not be
A person.
Yep, charged with or convicted of a violation for acts committed before the birth of the child, and then pick it up at including but not limited to on line 1.9.
Add there, included but not limited to, at the end. So Senator Maye Quade, we're trying to describe this properly here, and I think if you say a pregnant person, if they're no longer pregnant and the charge gets brought, it doesn't really work. So I think you'd almost have to say a person and then refer back to conduct before the child was born.
And Mr. Chair, you might want to include pregnancy somewhere in there. Only, yeah. Because if it's a person, it's any person.
We could say a person may not be charged with or convicted of a violation of this section for acts committed while pregnant and before the birth of a child, including but not limited to. Senator Maye Quade.
And thank you, Mr. Chair. I would want to make sure that we're confining that to the child that was born from that pregnancy. So,
The child?
correct,
Say the child instead of a child.
or children, yes. Mr. Chair, because I'm thinking, there are circumstances that could happen to other children that you could be charged with or convicted that you did while you were pregnant to other children.
Which we don't want to exclude.
Correct, yes.
So the child or birth of that person's child or children. I'm going to suggest that we take the best language we can get right now.
Yes, Mr. Chair.
See if we can get a consensus on the committee to pass it, understanding that tweaks could still happen, also understanding there isn't a House companion to this bill yet, so there will be other opportunities in this process to tweak the language a little bit, but we'll try to get the closest we can right now without spending the rest of the evening on it. Does that make sense, Senator Maye Quade?
Absolutely, Mr. Chair.
So let's see if we can get an amendment proposed here. Mr. Backus.
Mr. Chair and members, again, it would be a subdivision 3 for 609.378 exception. A person may not be charged with or convicted of a violation of this section for acts committed while pregnant and before the birth of the person's child or children, including but not limited to the use of drugs, prescribed or otherwise, and then the rest of the original bill.
Senator Maye Quade.
Thank you, Mr. Chair. That sounds wonderful, and I appreciate the minds.
Senator Westland, does that sound acceptable to you?
Yes, Mr. Chair. Mr. Backus is good at his job.
And Mr. Chair, members, and I
Mr.
think
Backus.
it's obvious, but this would be a delete everything amendment then to the original language.
So that would be the proposed amendment. Is there any further discussion on that proposed amendment? Senator Westland moves the amendment as described by Mr. Backus.
So moved, Mr. Chair.
All those in favor say aye. Aye. Opposed? No. Motion prevails. The amendment is adopted. Is there any further discussion on Senate File 1289 as amended? Not seeing any. Final comments from Senator Maye Quade?
I hope the rest of your night is uneventful and short.
Let's go. Okay. Senator Maye Quade, in terms of next steps, we could either dual track this bill, or we could send it to the floor, or we could lay it over. Do you have a preference? And by the way, Senator Howe, I know your ears are picking up. We're going to give the same option to the Minnesota Fire Bill that you came up to me while in recess. So you'll have the same option. Senator Maye Quade.
Thank you, Mr. Chair. I will choose door number 1, dual track, please.
All right, so the motion, understanding that we may insert the language into an omnibus bill also, but the motion from Senator Westland is that Senate File 1289 as amended be recommended to pass and be sent to the Senate floor. All those in favor say aye. Aye. Opposed? No. The motion prevails. Senator Maye Quade, you always give us something interesting to talk about.
Thank you, Mr. Chair.
Don't abuse the privilege, however. All right.
Mr. Chair.
All right, we're going to turn to Senator Oumou Verbeten's bill. Sorry, Senator Clark. Looks like the order is being selected for us, Senate File 1909. Senator Oumou Verbeten, we have Senate File 1909 before us. The intention is to lay this bill over, and we also have Ms. Deese as the testifier on this bill. So then perhaps she can head home after this is done. There's an A3 amendment in the packets, members, and this is the first stop, so that is an author's amendment. Senator Oumou Verbeten moves. I've got 2 amendments. Looks like we got 2 and 3. A3 is the one that you wish to adopt?
Yes, Mr. Chair, A3.
Senator Oumou Verbeten moves adoption of the A3 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. The amendment is stapled into your packet, appended to Senate File 1909. Senator Oumou Verbeten, go ahead and give us a brief description of your bill, please.
Thank you, Mr. Chair. This bill gives county attorneys administrative subpoena powers to obtain necessary evidence for wage theft cases. And as a reminder, wage theft occurs when an employer intentionally deprives workers of full payment for their labor. Losses to wage theft far exceed the combined value of all robberies, burglaries, larcenies, motor vehicle thefts tracked by the FBI. Minimum wage workers are just one subset of victims, losing $90 million in wage theft every year across the Twin Cities. And the most serious instances of wage theft also involve misclassification fraud. So when workers are misclassified as independent contractors, employers steal their wages, deny workers guaranteed protections like overtime pay, minimum wage, unemployment insurance, paid family medical leave, earned sick and safe time, and more. I also note that misclassification defrauds the government, of course, through tax evasion, which means less money for the services that we provide, but also through those payments that employers are expected to make to unemployment insurance, paid family medical leave, so on, programs that are an important part of our social safety net and really require everyone to pay their fair share. It's a growing issue, and there was an OLA report that found that approximately 1 in 5 workers are being misclassified. In 2019, the legislature amended Minnesota's criminal theft statute to include wage theft. But it did not amend the corresponding statutory authority for county attorneys to obtain necessary evidence for prosecuting wage theft via that administrative subpoena. And so that's what this bill is doing, is correcting that oversight. In general, county attorneys are authorized to use administrative subpoenas to compel production of certain records from third parties. Currently, the statute allows for the subpoena of financial records only in identity theft and welfare fraud investigations. Similar to these crimes, wage theft involves exploitation and fraud. And proving all of these crimes really does
require following the money. So in wage theft investigations, county attorneys are going to need to gather and review payroll records, payment records, contracts, other relevant documentation. It's really important for county attorneys to be able to do this in a timely manner. The longer that takes, the longer workers are going to have to go without their wages. And so again, this bill will allow them to subpoena those records and really ensure that criminal penalties in the Minnesota wage theft statute are enforceable. Thank you. Oh, I do also want to say, we'll hear from our testifier, but this is supported by Ramsey County Attorney's Office, North Central States Regional Council of Carpenters, SEIU, and AFL-CIO, and you should have letters of support in your packet.
Senator Oumou Verbeten, is there any known opposition to this bill?
There's no one here to testify in opposition that I'm aware of, and no one that I've heard of on the bill.
All right. Ms. Dees, briefly, please.
Thank you, Chair. I am the managing attorney of what's called the Community Prosecution Division of the Hennepin County Attorney's Office. It houses our Workers Protection Unit, which was established by the county attorney when she came into office. As Senator Oumou Verbeten indicated, wage theft was made a crime in 2019. So historically, these types of crimes had been investigated, or these types of violations, I should say, had been investigated by civil enforcement agencies. What we're seeing now is that it's still happening. It costs Minnesota over $100 million in lost tax revenue annually. And we just don't have the expertise yet in law enforcement, or frankly, the resources or capacity for our law enforcement agencies to give the full strength of investigations for this crime. We know that our law enforcement agencies also have an acute shortage of financial crimes investigators, particularly with these types of crimes that tend to be considered more white collar, similar to welfare fraud, identity theft of vulnerable adults. We need a way to assist our law enforcement partners to investigate these crimes. I just want to give a quick example of what this would look like. So we would have a victim who would call our office to report a crime. Maybe they had already reported to law enforcement or not. Maybe it was an allegation that they're working 80 hours a week without overtime pay, or they receive less than minimum wage, or they're not receiving adequate safety gear, or they don't have workers' protection insurance. We, of course, then contact our law enforcement partners. Either they're very excited about the possibility of investigating it, but won't be able to get to it within several months' delay, or, like I said before, they don't have expertise in this field, or they just don't, frankly, have the bandwidth to investigate. That would leave the county attorney's offices across the state to assist with these incredibly important investigations. They could compel or request the documents that are already required by law for these employers to maintain. So these employers are expected to maintain these not only for their own tax purposes, but to comply with the Minnesota Fair Labor Standards Act, which is 177.30. So we are not compelling anything that would otherwise not already be maintained and required by law. Again, this is expanded powers on what already exists for county attorney offices. It would not only assist us with this, but it would increase the ability of our criminal justice system to hold accountable those who are undercutting the fair labor market. I am happy to answer any questions, Chair Latz, that you have as it pertains to the problem or the amendments proposed.
Is there anyone in the room that wishes to testify in connection with this bill? Not seeing any. Any discussion from members of the committee? Senator Anderson.
Thank you, Mr. Chair. I'd like to ask a question of council. If, when it's mentioned here, business entities, would a nonprofit be considered a business entity?
Ms. Primo.
Mr. Chair and members, under this statute, that I think that it would capture a nonprofit entity as well. It's not defined in the statute.
Senator Anderson.
Mr. Chair, Ms. Primo, do you think we should add nonprofits into it if it's not defined now?
Ms. Primo.
Mr. Chair, that could be a question for the advocates of the bill and the author if they believe they want to clearly capture that intent to get at potential records held with a nonprofit and the language doesn't clearly capture that, then that could be a decision for the committee.
Senator Oumou Verbeten, or Ms. Dees.
Thank you, Mr. Chair. I don't see any problem with including that.
Ms. Primo, could you prepare language for an amendment to make that addition?
Mr. Chair and members, I think Senator Anderson may have been looking at line 2.26, if that's correct, because this provision, this new authority that's being created applies to the records of an employer or other person who is the subject of a wage theft investigation. And business entities is only used in current law to clarify that the administrative subpoena power applies to the records of business entities and not to the private individuals.
Mr. Chair,
Senator Oumou Verbeten.
so if this is already applied to employers, that could be a business or that could be a nonprofit. Again, I don't have any problem with doing so. I want to make sure they can access the records from any employer.
Mr. Chair, I was just thinking that when we put business entities as the part of the amendment that's going on here, that we just add nonprofits right after that, or nonprofits.
I understand there's some ambiguity, I think, Senator Anderson, in paragraph B here. Ms. Primo, on line 2.26, what does current statute mean when it says this provision?
Mr. Chair and members, that's being somewhat addressed, I think, by the amendment.
Mr. Chair, I think we're talking about line 216 also.
Mr. Backus, say this is already addressed to some degree in the A3 amendment?
Mr. Chair and members, yeah, your specific question about what provision applies to, if you look at line 1.8 of the A3, you'll see that that whole sentence is being made into its own paragraph, and subdivision is replacing provision, just to be clearer.
Would Mr. Backus, would then that subdivision, which is subdivision 1 of the statute, only allow these administrative subpoenas to go to business entities? Or would it go to all employers?
Mr. Chair, members, I think that sentence is, again, it's current law. I think it's supposed to protect administrative subpoenas to go after the information of private individuals, like their personal records and things like that. So I think it's meant to say that an administrative subpoena can only go after the records of business entities and not private individuals or their dwellings.
But the question would be whether business entities excludes nonprofit employers. Senator Westland has a suggestion.
Thank you, Mr. Chair. So
Answer.
in Chapter 308B, which deals with businesses, social and charitable organizations, in 308B.005, there are definitions, and it is a term of art. So a business entity is a company, limited liability partnership, or other legal entity, whether domestic or foreign, association, or body vested with the power or function of a legal entity. A nonprofit is a legal entity, and it would be covered by that particular definition, Mr. Chair. So it's a term of art that's already in statute that has a specific meaning. So I don't think that we need to add anything in this provision to further define what a business entity is.
Senator Westland, does 308B apply to Chapter 388 then?
Mr. Chair, we could certainly make a reference back to that, to 308.B.005, but, you know.
It might in its own terms in 308B, it might say it applies as well.
I don't know that 308B is applying itself to other things, but I always feel like if there is a definition in statute, that we should be consistent in applying that definition. So we certainly could say this provision applies only to the records of business entities as defined in 308B.005 subdivision 7. I don't necessarily think that's necessary, but that would get to the specific definition of a business entity.
Mr. Chair.
Senator Anderson.
Thank you, Mr. Chair. To council, is there a cross-reference to that we could reference to and move that, the cross-reference to this?
The corollary question would be whether or not a cross-reference would be broader in impact. But Ms. Deese, how are county attorneys using this provision? Are they treating all employers basically as business entities? Mr. Backus is indicating that the purpose of that language is to say you can't get private individuals' records, basically. You've got to be doing an entity's language. Ms. Deese?
Mr. Chair, yes. If this law is passed, that would likely be the county attorney's interpretation, that business entity would, of course, include a nonprofit agency. Of course, it has not yet passed, and so I think business entity, when it was originally created, was probably considering things more like financial institutions. But I do think, as Senator Westland indicated, it would capture a very broad scope of what is a business entity.
To be more clear, do you think it would be helpful to make a cross-reference back to the Chapter 308B definition of business entity?
Mr. Chair, yes, I do.
Senator Anderson's nodding in agreement.
Let's move it. 5 o'clock.
I don't think you made up that phrase.
5 o'clock's coming soon.
Council, any reason you think we shouldn't add a cross-reference to Chapter 308B's reference or definition? Mr. Backus?
Mr. Chair, members, I think I'll defer to the will of the committee on that. I'm not aware of any.
All right, Senator Anderson moves on line 2.26 of Senate File 1099. Mr. Backus has a better way to do this. Mr. Backus.
Mr. Chair and members, it's a little bit confusing just based on the amendment, but I'll describe it more conceptually. If you look at the bill on page 2, after line 2.27, we would add another new paragraph, because again, the sentence that reads this provision is going to be paragraph C, and it'll be this subdivision. But the new subdivision will be paragraph would be paragraph D, and it would be phrased, as used in this subdivision, business entity has the meaning given in section 308B.005, period.
Senator Westland, good. Senator Anderson, good. Senator Oumou Verbeten, good. Friendly amendment?
Yes, thank you, Mr. Chair.
Senator Anderson moves adoption of the amendment as described by council. All those in favor say aye.
Aye.
Aye. Opposed? Amendment passes. Motion passes. Amendment's adopted. Say it properly. Senator Howe and then Mr. Heller. Senator Howe.
Thank you, Mr. Chair. And I guess I just got the question. I don't know if this is for council or for Senator Oumou Verbeten, but isn't Dolly, Department of Labor and Industry, the ones that investigate wage theft currently? And I'm just wondering why, maybe I'll ask that question first, and then, because that's from my dealings with my business and with Department of Labor and Industry, that's where this currently gets investigated first?
Mr. Chair.
Senator Oumou Verbeten.
Thank you. Thank you, Senator Howe. They do have enforcement authority over wage theft. They can issue out penalties, but wage theft is also theft, and there are criminal penalties, and that's why the county attorneys are looking for this subpoena power to aid in their criminal investigations.
Thank you, Mr. Chair, but doesn't the Department of Labor and Industry have most of that information already?
Ms. Deese.
Thank you, Mr. Chair. Senator Howe, the Department of Labor and Industry is a civil enforcement agency, so yes, in their investigations, they may obtain this documentation. That is separate from a criminal investigation. We would still prefer in a criminal investigation to maybe have parallel but keep it clean and compel the documents ourselves versus relying on a civil enforcement agency to obtain those documents for us.
Mr. Heller.
Hello again. My name is Rick Heller. Unofficially represent the Twice Exceptional Apprentice Disabilities. Wearing a camouflage hat with suspenders and a green shirt. Come and testify on this bill. I'll give a little history. I've been working for the Carpenters for 40 years. Twin City Carpenters. I approached them to ask them if I could do bannering. And they said no for 4 years.
So, Mr. Heller, I'm going to ask you to please focus on the substance of this bill only.
Okay,
We
so
don't have time for
I
anything
agree
else.
with this amendment, but it's because it's cloaked. I think nonprofits need to be included. That includes that. Just that when you put it into another number, people won't know that's important. If it's wage fraud, they use their banner carriers as non-union members and pay them substantially less, which I found interesting. But yet when it came to the members, they have to pay them as far as their role and duty. So anyway, I just thought I'd kind of raise that awareness that maybe they're not exploiting because they're just doing banner carrying. However, their own people, their union for conflict of interest likely are not doing bannering for potential lawsuits. So they put a firewall. If you go to the federal documents, M3s, that they report to the federal government, they do have those people names in there, substantially less number saying banner carriers. So to let you know, there's a way of splitting hairs here about having people do certain things within unions as well, and just make you all aware of it. Thank you again for this opportunity to speak.
Thank you, Mr. Heller. Any further discussion from members of the committee on this bill as amended? Not seeing any. Senate File 1909 is laid over for possible inclusion. Senator Oumou Verbeten, next bill is 1609. Staff will hand out their materials. Members, we have a fiscal note on this bill. It is coming at zero cost. If Ms. Martinson could come forward to testify. Senator Oumou Verbeten, if we can go ahead and give us a brief description, please, for on Senate File 1609.
Thank you, Mr. Chair. In 2023, we reformed the aiding and abetting felony murder law and provided retroactive relief for eligible individuals. However, the legislation did not explicitly preserve the original conviction date, and this has resulted in those who are resentenced receiving a reassigned conviction date. You can see an example of this on the one-pager that was provided in your packets. My testifiers can also speak to this, but Senate File 1609 ensures the conviction dates remain unchanged to accurately reflect the original date in background checks. In California, the similar reforms that they had on aiding and abetting preserve the original conviction date while replacing the murder conviction with the appropriate predicate felony. To date, approximately 20 individuals have been resentenced under the law, and this bill would allow courts to restore their original conviction date and ensure that future cases retain the original murder conviction date while replacing it with the predicate felony conviction. I'll just say many individuals being resentenced were originally convicted over a decade ago, and so updating their conviction date back to 2024 or 2025 can create some significant barriers by negatively affecting their ability to seek housing, employment, and higher education. And so this bill really ensures that those reentering society have a fair opportunity to rebuild their lives after serving their time.
Senator Oumou Verbeten, does this bill essentially provide for accurate record keeping in situations where the record keeping may not have been accurate?
Mr. Chair, yes, I would say it's accurate because that's what the sentence should have been, and so it's ensuring that the date is accurate with when the resentencing happens.
Do you know of any opposition to making sure that the records are accurate?
I'm not aware of any opposition, Mr. Chair. I was very happy to see the fiscal note come in at 0. That was one of my biggest concerns.
All right, Senator Oumou Verbeten, there are 2 testifiers next to you, but I'm willing to hear testimony, but we don't need to hear why the felony murder law was changed, all the policy reasons behind it, why it's important to have accurate records, besides the fact that we want our records to be accurate. So with all due respect, if you have nothing to add to that, we are really running out of time here with a long agenda left. So unless there is some opposition to this proposal, I'd rather just focus on the question right before us.
Okay.
Can we do that? Does anyone in the room wish to testify against this proposal? Is there anyone on the committee that has any questions about or discussion about the proposal before us? I'm not seeing any. Senator Oumou Verbeten, for Senate File 1609, the intent is to lay this bill over for possible inclusion. That's what we're doing on Senate File 1609. Members, we now have Senate File 206 that will be considered. Staff will hand out that bill. There is an A6 amendment, which will be distributed as well. This is the first committee stop for this amendment, and it looks like in our packet there's also an A4. I'm guessing that is being replaced by the A6. A6 is an author's amendment. Senator Oumou Verbeten moves adoption of the A6 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Oumou Verbeten, I don't know exactly. Why don't you tell us briefly about this bill as well, and we will hear from your testifiers.
Thank you, Mr. Chair. I'll try to keep this brief. But we did have a felony murder task force in 21 that led to the recommendations passed in 23. And then there was the task force that continued in 2024, made recommendations, and this bill is the result of those recommendations. Essentially, it provides the prospective relief for first-degree murder and second-degree intentional, as well as the retroactive relief for first degree, and that's based on the recommendations that were voted on by the task force. There's also a section that continues the task force to do similar work, and I think I'm waiting on the fiscal note from that.
I'll just defer to my testifier to talk a little bit about the task force and why they provided these recommendations in the interest of time.
Thank you, Senator.
Go ahead and
Mr. Chair,
introduce
members.
yourself.
My name is Greg Egan. I'm the former task force chair of the past iterations of the aiding and abetting felony murder task force. I was appointed directly by the Minnesota Association of Criminal Defense Attorneys. I was honored to lead the task force in robust collegial discussions amongst 11 highly qualified experts of diverse backgrounds. Task force membership included 2 elected prosecutors, 2 law enforcement officials, representatives from a victims' rights organization and the Minnesota Department of Corrections, as well as a family member of an incarcerated individual, the executive director of the Minnesota Sentencing Guidelines Commission, a law professor, and the state chief public defender. We expanded on the work of the 2021 task force to establish and collect and analyze data, hear stories, conduct legal research, and the research was focused on broader issues of Minnesota's aiding and abetting liability and broader issues of the felony murder doctrine. Mr. Chair, I previously circulated our report to Senate and House leadership. The bill before this committee contains 2 substantive policy recommendations. The first is to equalize criminal intent for primary actors and accomplices under first-degree premeditated murder and second-degree intentional murder. Under the current system, an accomplice can actually be convicted for murder while having a lesser intent than the primary actor. This recommendation carried unanimously through the task force. The vote was also unanimous for retroactive application with respect to aiding and abetting first-degree murder only. The bill before you reflects that recommendation. It does not, however, include a provision for retroactivity for aiding and abetting second-degree murder. The second reform is to create an exclusive list of underlying felonies for second-degree felony murder that would parallel the list already contained in first-degree felony murder. This would provide uniformity and clarity. The list would exclude general assaults, which would finally bring Minnesota into conformity with the overwhelming majority of U.S. states and territories. This reform also garnered strong majority support from the task force. Racial disparities are rampant under the current rule. Retroapplication is not included for the second-degree felony murder reform. That was not a task force recommendation, so faithfulness to those recommendations was an important priority in crafting the bill before you today. In sum, it should not be easier to convict accomplices than primary actors. Moreover, having general assaults trigger second-degree felony murder undercuts proportionality, fairness, and equity under a carefully gradated wrongful death statutory scheme. The problem in Minnesota is magnified because assault law generally requires no intent with respect to level of harm. Reform is urgent. Voting in favor of this bill would catalyze a major step forward in the realm of fundamental fairness, clarity, and public safety. I thank you for your time and thoughtful consideration of this bill, and I'll make myself available for any questions. Thank you.
Thank you, Mr. Egan. Ms. Martinson, are you here to testify? Do you have anything that you'd like to add?
Yeah, sorry, I just got kind of nervous. Good, I guess it's evening now.
Well, not yet. It's still light out.
Chair Latz and committee members. My name is Brianna Martinson. I was released from prison due to the bill that you guys passed in 2023. So I just want to thank you all first for that. I know I wouldn't be where I am today in front of you guys if it weren't for that. So I don't take that lightly. Yeah, sorry. This bill that we're talking about right now is really dear to my heart. Most of the women in Shakopee that I was with for over 6 years, I grew really close to, and most of them are in prison for life sentences for a murder that they didn't plan or commit, and I grew really close relationships with them. The difference in their cases and mine is that I took a plea deal in mine that allowed me to get out based off of the new law that passed, and these women took their cases to trial and ended up losing because they went to trial initially because they were like, how can I be charged and convicted of a murder I didn't plan or commit? But the way the law is and was written, because you committed a felony, you're just as responsible for that murder. But how can anyone really be responsible for anyone else's actions? But yeah, I'm going to give a couple examples of the two of the women that are in for the rest of their lives. One I was roommates with for 3 years with a woman named Jamie Larson. Let me tell you, those cells are nothing but close quarters to really get to know a person and see someone's true colors. And Jamie went in when she was 22 years old. She's now been in prison for 21 years. And she is the most selfless, caring, and loving individual I've ever met to this day. She's helped me grow so much as an individual in areas of self-love and respect, and she's helped me find my voice and learn to accept a lot of things. When the law changed for second degree was happening last year, she knew it wasn't going to affect her, but was so genuinely happy for everyone else, even after her serving 20 years. When I got released out of prison a little over a year ago, she even sent me money to get what I needed because she heard it was expensive out here, and she wanted to help me. When you're incarcerated, you make around 50 cents at the on average an hour at our prison jobs. So the amount she sent home to me was hard-earned money from the last many years she was saving. She's the type of person that's always making sure everyone is okay and set up for success, even when she is the one locked inside and struggling herself. Jamie is now 43. She's lost the ability to have kids. Her mom is 74 and she's super sick. She can't help her in any way. When Jamie was facing her charges and everything, she was offered a 15-year plea deal before she went to trial. But she didn't take it because, like I said earlier, she thought that there's no way that she could be guilty of a murder that she had no idea about. She now has to die in prison because she didn't take that plea deal. Another friend of mine is named Maureen Anilobi, who also has a life sentence. Mo, we call her. She's so intelligent, kind, and funny. She's almost also done with her law degree. She's on the Restorative Justice Committee, along with Jamie, trying to give back from the inside. They don't play victim or anything like that because of their circumstances. If anything, they try to do better and be better. But these women aren't isolated individuals either. There's so many more. But a lot of times I feel like we just look at people's label or the X on their back. But they're people. They're humans with stories who want a second chance to reach their full potential, to do better, to be citizens in society. And I know for a fact if they got the opportunity like I did to be released from prison, that they wouldn't take it for granted either. Thank you so much for listening today.
Thank you so much for coming here to testify.
Yeah, thank you.
Any further testimony you'd like to present at this time, Senator Oumou Verbeten? We'll open it up for discussion among the committee. Any of the committee members have any questions or discussion? I'm not seeing any. Members, the intent is to move this bill to state and local government, and then we expect it'll return here, but there is a task force in here that they need to consider. All right, Senator Oumou Verbeten moves that Senate File 206 as amended be recommended to pass and be re-referred to the Senate Committee on State and Local Government. All those in favor say aye.
Aye.
Opposed? No. Motion prevails. All right. Senator Oumou Verbeten, Senate File 666. Lucky you to get that Senate file number. Members, the intent is to move this to Health and Human Services, and then it will be returned to us, is the expectation. If the testifiers on this want to come forward at this time, that's fine. Senator Oumou Verbeten, can you give us also a brief description of your bill?
Thank you, Mr. Chair. Senate File 666 would eliminate the predatory fees on all forms of communication, including video calls, emails, electronic messages in our state correctional facilities. In 2023, we took the important step of eliminating the fees for phone calls, and now we have an opportunity to enact this policy to improve the lives of countless hardworking taxpaying families across the state. I will just note, in the interest of time, there is a fiscal note that was completed for the bill, showing that there's already some savings. One thing that has changed since last year is the FCC ruled on this and placed a number of caps that's resulted in lower rates already for the Department of Corrections. So there are a number of ways to scale this bill, potentially providing some, an additional form of communication services that we're not providing right now, perhaps the electronic messages. Of course, I'd love to see us incorporate all of those. But again, just want to note out that there's some flexibility there, as well as just looking at the timing to make sure that can align with the current RFP process that the department is undertaking. So I'll leave it at that to leave room for the testifiers.
Thank you, Senator Oumou Verbeten. I know we have a couple of testifiers here, and I know you've been waiting patiently to testify as well. I just, given the hour, we really want to hear what you have to say. I'm just going to ask you to be as succinct as you can in communicating what you'd like to. So please go ahead and identify yourself.
Good afternoon, Chair Latz and members of the Senate Judiciary and Public Safety Committee. My name is Alyssa Washington, and I'm the founder of the Wrongfully Incarcerated and Oversentenced Families Council, Minnesota. I'm also the wife of Cornelius Jackson, who has been wrongfully incarcerated for the last 19 years in a Minnesota prison. I want to express my deepest gratitude for your continued support in keeping communication free in our state's prisons. For families like mine, this is more than just a policy. It's a lifeline. Free phone calls have been a bridge of connection for many children like mine, whose parents are incarcerated, but more needs to be done. Video calls and e-messages add another level of bonding for our children, sharing smiles, life events, and memorable moments. Unfortunately, in Minnesota, a 15-minute video call is $3.50. These costs add up for every month, causing a sense of guilt on my son's face every time he wants to see his dad. With Cornelius behind bars, free communication will allow us to maintain a strong family bond without the added financial burden. It means his son can continue to connect with his father, receive his support, and feel his presence, even from a distance without thinking about the cost attached. This connection is vital for the emotional well-being of both of them. It's a small investment with a big dividend because it keeps his son stable in school and at home, and also keeps Cornelius safe while in prison and seeking exoneration. Your continued support ensures that these crucial family connections remain strong. Thank you for helping us keep these bonds alive. I humbly request your vote for SF 666. Thank you.
Thank you for your testimony, ma'am. Go ahead and introduce yourself, please.
Hi, good afternoon, Honorable Chair and members of the Judiciary and Public Safety Committee. My name is Brandy Earthman. I work with IWAC, and I'm the co-chair of Rush City Prison. I also have 2 loved ones inside the state prisons here. And as a profound
As a proud parent, I stand before you today inspired by the remarkable resilience of my son, Maye Burrell, who is currently incarcerated at a Minnesota state prison. Despite facing formidable challenges during his childhood years, with his father, Maye Burrell, incarcerated for most of that time, my son's story is one of hope, transformation, and the indomitable human spirit. 5 years ago, his father's sentence was commuted, making the beginning of our incredible healing journey. Today, I am deeply grateful for the opportunity to express my heartfelt appreciation for your unwavering commitment to ensuring free communication within Minnesota's prisons. The gift of free phone calls has been a game changer for my son and me and other families, also enabling us to engage in meaningful conversations that have been instrumental in our healing process. I humbly request that this committee support the expansion of free communication services, empowering my son, his father, other families, and me to continue on our journey of healing, growth, and rehabilitation. The ability to communicate without financial hardship has brought immense joy, comfort, and a renewed sense of purpose to our families. Video calls have been a source of inspiration, connecting my son to his home and roots, and giving him hope for a brighter future. The moments we shared during these calls have been profound, and I am eager to see the positive impact that expanded communication services that can have on families like mine, uplifting and transforming lives one conversation at a time. And for that reason, I ask that you consider voting yes on Bill SF 666.
Thank you for your testimony today. Appreciate it very much. Senator Oumou Verbeten, are those the testifiers that you have today?
Yes, Mr. Chair. I don't think we have anyone online, so we can just move to committee discussion.
Okay, is there any discussion from members of the committee? I'm not seeing any members. The intent, as I said, is for this to go to Health and Human Services because there's a provision that affects their facilities as well. And then I expect it'll come back here for, if it passes there, for consideration of inclusion in our budget bill. Senator Oumou Verbeten moves Senate File 666 be recommended to pass, be re-referred to the Senate Committee on Health and Human Services. All those in favor say aye.
Aye.
Aye. Opposed? No. Motion prevails. Senator Oumou Verbeten, you have concluded your time in the hot seat for today.
Okay, thank you.
Senator Clark, been waiting patiently. Okay, not so patiently. While you are approaching the testifier desk, Senator Howe moves that Senate File 1427 be taken from the table, having voted on the prevailing side, and further moves that Senate File 1427 be recommended to pass to the Senate floor. Members, this was the Minnesota Fire Bill that we already heard earlier. It was laid over for possible inclusion. Senator Howe has requested that the matter proceed on its own to the Senate floor. The House counterpart has done so as well. We'll probably dual track this because it's not certain whether this will be Senate floor time to take it up. But at this time, we'll honor Senator Howe's request. Senator Howe, do you have anything else you'd like to add to this before we take action on your motion?
No, greatly appreciated, Mr. Chair.
All right. Any committee discussion? All those in favor say aye. Aye. Opposed? Motion prevails. Senate File 1427 is on its way to the Senate floor. Senator Clark, which of your two bills do you want to hear first?
Chair Latz, 1626, please.
Senate File 1626, Department of Corrections Licensed Facilities. You have with us Commissioner Schnell. Thank you for listening to our hearing most of today. Senator Clark, you want to give us a brief summary of the bill, or would you like to have the Commissioner do that?
I will give a brief summary, Chair Latz.
Please proceed.
Thanks, Chair Latz. Thank you for the opportunity to present Senate File 1626, the Licensing Improvement and Simplification Act. This bill warms my heart as it takes a whole bunch of pieces that were brought and sort of cobbled together over time and make it simpler, clearer, and easier for all of us to understand. Since the inception of the Direction of Corrections licensing statute, it has been amended almost 40 times. Because of this, its provisions are scattered, confusing, especially regarding which requirements apply to which facilities, adult, juvenile, state prisons, or combinations of both. And as a result, licensed facilities struggle to navigate and understand the bill and what is required of them by the state. So this proposal seeks to address these issues by reorganizing it and providing clarity to the law. By removing redundancies, eliminating outdated references, and using more accessible, plain language, we can make the statute simpler and easier to understand for the licensed facilities to follow. The intention behind this bill is simple: to make the law make sense. By improving clarity and accessibility, we can ensure that our correctional facilities operate under a statute that makes sense to everyone. Additionally, many of the licensing requirements in this bill were negotiated and agreed upon in collaboration with the Minnesota Sheriff's Association and the Department of Corrections. These discussions led to the creation of the Hart-L-Sherrill Act, which was passed in the bipartisan manner in 2021. This act helped to address some critical issues regarding facility licensing, particularly around conditional licensing for adult facilities. And we are now extending those same principles to juvenile facilities to ensure consistency and fairness across the system. This bill builds upon those negotiated agreements to provide a more unified and understandable and manageable licensing structure across all types of correctional facilities. With that, Chair Latz, I'll turn it over to Commissioner Schnell, who will provide further details to this proposal.
Members, the intention is to lay this bill over for possible inclusion. Commissioner Schnell.
Chair Latz, members of the committee, Paul Schnell, the Commissioner of Corrections, and I had some time to edit here, so I cut it shorter. Senate File 1626 just reorganized the law into 3 distinct sections, separating out the jails, juvenile facilities into their own separate statutes, and relocating provisions that apply only to state prisons into sections related to the DOC. The change really reflects the DOC's current practices, for one, which includes providing both inpatient and outpatient treatment to both adults and juveniles, which is a reflection of the evolution of care, the continuum of care within the facilities. The bill also takes conditional licensing structure from the Hart-L-Sherrill Act passed in 2021 and applies that to juvenile detention systems. Under the current system, the remedy for juvenile facility license intervention is revocation in its entirety, like an on and off switch. This bill would make available the licensing remedy from Hart-L-Sherrill Act and apply it to those juvenile facilities found in significant violation, where they could be subjected to a conditional license order versus revocation of the facility license altogether. Finally, the bill closes a critical loophole regarding death review requirements in adult facilities. A string of tragedies at the county jails reveal the loophole in death reporting and review requirements caused by statutory language. After multiple individuals died following medical events occurring in jail and following medical interventions being initiated at those jails, the deaths went either unreported to the DOC or the death was not subjected to the required review because they were furloughed or transferred to a hospital and died there. This bill seeks to close this gap and ensure that all deaths linked to medical events occurring in the facility are reported and reviewed, no matter the individual's custody status, to guarantee that such tragedies are thoroughly reviewed. Overall, Senate 1626 streamlines licensing requirements to ensure compliance and increase accountability. And I would ask your support for this bill and would stand for any questions you or the committee may have.
Thank you, Commissioner. We also have some testimony coming from Rick Hodson. Is Mr. Hodson present? Come on forward, sir. You go ahead and identify yourself for the record and present your testimony.
Welcome.
Thank you, Senator. My name is Richard Hodson, H-O-D-S-D-O-N. I am legal counsel for the Minnesota Sheriff's Association. At least that's the hat I'm wearing today. and I am here to testify in opposition to the bill as presented. I appreciate the statement made that among the stakeholders consulted was the Minnesota Sheriff's Association. It would seem that most of our consultations and our suggestions and our advice went unheeded. I submitted the other day, and I realize that it hasn't caught up, I submitted a multi-page document raising our objections, specific substantive concerns, as well as overall policy concerns. It is detailed and substantive, and I tell you, if we had started with this bill at 9 o'clock this morning, we'd still be here now if we went into those detail, and I know that's not what's going on here. We don't believe that the Department of Corrections has heard our concerns. Some of the things like the definitions would require a report to the Department of Corrections from every jail in Minnesota every time an inmate experienced medical care. That's what this bill is proposing. That's just one example I'll give you in my very short allotted time here. We feel there are major problems with this bill that have been unlistened to from the Minnesota Sheriff's Association. There are, to the extent this is continuation of some current practices, that is not a consolation in Minnesota sheriffs. We believe the Minnesota Department of Corrections has been already acting inappropriately and unfairly with many of the jails in the state of Minnesota. And that is in the materials that you will be getting from me. And with that, I will also keep my time short. Of course, if there are questions and specifics, I'd be happy to share now or with any member of the committee offline at any time.
Thank you, Mr. Hodgson. I will note again, the bill will be laid over for possible inclusion, so there is time for further evaluation of that input. Anyone else in the room want to testify? Mr. Heller, come on forward. And again, I'm going to ask you to keep your testimony focused on the substance of the bill before us. Thank you. Mr. Heller.
Thank you, Chair and members on Judicial and the Senate. My name is Rick Heller. Unofficially represent the twice exceptional print disability, white male with a beard, camouflage hat. Discussion will be, if I can be allowed, the school to prison pipeline. Many students that are twice exceptional, which is undefined, people with print disabilities undefined in statute, go through the pipeline. If people could go to 5.17 under rulemaking and consider the following items: health, literacy. Library of Congress Services in 2019 broadened the spectrum who can certify a print disability. And Department of Justice did cite the Minnesota Correction in 2022 for GED programming corrections. Frankly, I just don't know how that might fit into this, but everyone needs an opportunity to acquire the printed word effectively. And I'm always open to questions and talking offline about this piece. Relates to 1703 this year. And once again, if they would bake this, if the commissioner would yield to the question, would they bake that into the cake regarding the health literacy check? State Department Education decided 8th grade for reading disability, or should I say print disability, depending on how you mix the Kool-Aid here. So through the chair, would the commissioner, the conversation ahead, yield to that question or not?
Mr. Heller, we'll give the commissioner an opportunity to respond to your comments when you're concluded if he has anything to add to it.
Thank you again for this opportunity to speak.
Thank you, Mr. Heller. Appreciate that. Commissioner, if you'd like to come back to the table, we'll open this up for discussion unless you have something specific you'd like to add in response to Mr. Heller's testimony.
Mr. Chair, I did have an opportunity to speak with Mr. Heller, and I will be following up with our ADA folks and education people.
Thank you, Commissioner. Senator Howe.
Thank you, Mr. Chair. And I just noticed that they're doing all the local facilities and having experience inspecting those facilities from a fire standpoint. Somewhere along the line, we should discuss on how that's all going to be coordinated and what you're looking for and the qualifications you have as compared to state and local fire officials and building officials. So thank you.
Senator Limmer.
Thank you, Mr. Chair. Senator Clark, when you started to explain the bill, I think you used the words that this was kind of a technical rewrite and then consolidated into one area or chapter. Is there anything substantive in this bill that would be a different policy than what it currently is?
Chair Latz.
Senator Clark.
Chair Latz, Senator Limmer, I will need to phone a friend with Commissioner Schnell.
Commissioner.
Mr. Chair, Senator Limmer, the substantive factors are really redefinition of the services we provide, providing the Hardell-Sherrill Act elements to be able to address licensing issues, and probably one of the core areas is really heavily focused on the area of the death review process, which is required in statute, where there was some language relative to placement or being committed to the custody of that facility. That fundamental change, because if you look at the entirety of that sentence, there was also elements that this legislature was concerned about medical services that were initiated in the jail.
Any other discussion? Mr. Hodson, you approached, did you have something specific in response to that, or just want to make yourself available?
No, Senator. In response to Senator Limmer's question, from the sheriff's perspective, the answer is absolutely yes. There are major substantive changes in this bill from our perspective that have not been vetted through our association, our organization, or as we've said, not that we've been listened to.
Mr. Chair?
Senator Limmer.
Mr. Chair, what's your intent on this bill? Is this to be laid over for possible inclusion, or?
That's correct, Senator Limmer.
All right. There'll be time to analyze this a little further, at least privately.
That's correct.
Okay, thank you.
Any further discussion from members of the committee? I'm going to encourage the chief author and the commissioner to take a close look at the submission from the Sheriff's Association and see if there's a way to incorporate recommended changes or requested changes that can be consistent with the goals of the bill.
Thank you, Mr. Chair. We will do that.
It's worth sitting down and going through that in close detail. Thank you. Senate File 1626 is laid over for possible inclusion. And members, our last bill for today, Senate File 2089, Senator Clark on data practices modifications.
Thank you, Chair Latz.
Senator Clark.
Chair Latz and committee, I have an A1 amendment to get this into the situation that I'd like to discuss it with you with. And I'll offer the A1 amendment.
Senator Clark offers the A1 amendment as an author's amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Clark, to your bill.
Thank you, Chair Latz. Committee, Senate File 2089 is the Department of Administration's bill to improve the data challenge appeal process and protect private data. An individual has the right to challenge data about themselves held by a Minnesota government entity if they believe it to be inaccurate and or incomplete. These challenges can be appealed to the Commissioner of Administration. The bill proposes updates to the data challenge appeal process in two ways. First, it allows not public data to be shared between agencies to facilitate appeals. Currently, data challenge appeal information is assumed to be public, but government entities may need to submit private data to facilitate appeals. Second, it keeps inaccurate or incomplete data private at admin. This ensures that private data stays private during the data challenge appeals process. And it prevents further dissemination of incorrect or incomplete data when the commissioner orders data to be corrected, completed, or destroyed. Challenge data that are determined to be accurate or complete will remain public. I'll turn it over to my two testifiers to provide more details from the Department of Administration's Data Practices Office, Taya Moxley-Goldsmith and Casey Carmody.
Director Moxley-Goldsmith, welcome to the committee.
Good afternoon, Chair Latz and members. My name is Taya Moxley-Goldsmith. I'm the Director of the Data Practices Office at the Minnesota Department of Administration. We're a statewide resource on data practices for government and the public. Thank you to Senator Clark for authoring the bill and for the committee for hearing it today. I think that was a good summary of what the bill is doing. I would just add that we are building on some work we did last year to provide more clarity and efficiency to this particular process. And Assistant Director Casey Carmody and I can stand for any questions that you have for us.
Members, the intent is to refer this over to state and local government when we're done. Any discussion from members of the committee? Any difficult and challenging questions for Senator Clark?
Chair Latz, I'm headed to the Northwest Metro to watch a track meet, so if any of you want to carpool with me, I'm going to St. Michael, if you want to join.
All right, seeing no further discussion in Senator Clark's lucky evening here, Senator Clark moves that Senate File 2089 as amended be recommended to pass and be re-referred to the Senate Committee on State and Local Government. All those in favor say aye. Opposed? Motion prevails. Members, our next meetings are going to be next week, Monday and Wednesday, 12:30 in Capitol G15, and then back in this room on Friday, March 28th at 9 a.m. Members, thank you. I think we've done excellent work today. Appreciate the careful attention to the bills and to the language in the bills, doing what the Judiciary Committee does best. And with that, we are adjourned before 5:30. Have a good evening and weekend.